I just can't think of them now. The 70% thing. We've had that.
Mr. Glasgow's response.
Yes, Mr. Glasgow's response. And we're waiting on the conditions, I think, and that's it, other than the obligations, which will be signed and sent in 3 weeks. So unless there's anything else I've missed.
The only thing, Madam, you did ask for a note on the workspace provider list.
Okay, yeah.
And I'm told that we're still awaiting input on that from the relevant people within the council. Whether we'll get it today, I don't know. What I would say is that because it's primarily relevant to the Section 106, if we don't get it by the end of today, I would suggest we obviously try and put it in as soon as we can. Yeah. But as a long stop, if it's in at by the same date the Section 106 has to be in, then you can look at it alongside that. It will obviously share anything we get with the appellants as soon as we have it.
Yeah, that's great. I mean, it doesn't need to be anything overly formal. If it's just an email or something, just to confirm that. That's
exactly.
Fine. Yeah. Okay. All right. Any other housekeeping points this morning? No. So we've got 3 closings to hear. We'll take them with council first, Historic England, and then the appellants team last. We'll have breaks in between just to allow any last minute finessing, etc. I'm hoping there's printed copies available for me to follow. So, yes. And if you can email them through to the programme officer as well, and she'll put them on the inquiries documents list after we've sat today, just in case there are any typos or anything that want to be corrected.
And Madam, would you like them in Word? Sent electronically in case there's anything you need for the purpose of reporting?
Actually, yes, because for reporting the cases, actually they're helpful in
yes.
Without giving too much away. Yes, that'd be really helpful. So, okay, well, if you're ready then, Mr. Phil.
Yes, Madam, I'll have my note distributed. What I would say is, in order to seek to keep reasonably within my time estimate, I will not read all of it out. Mm-hmm. I'll let you know as we're going along when I'm going to skip forward. It's primarily obviously there in writing for your benefit, and I have decided sort of in advance which bits I think I can justifiably not read out today.
Yeah, of course I will be reading all of it.
That's what I
just for clarity. But
so, Madam, would you like me to begin?
Yes, if everyone's ready.
Thank you. Madam, I start with an overview. Neither of the 2 schemes can properly be said to constitute sustainable development or good design. The height and scale of both proposed towers are driven by commercial imperatives, seeking to maximise the delivery of office floor space rather than following a design-led approach to find the most appropriate form of development that responds to the site's capacity for growth. Both schemes represent overdevelopment of what is agreed to be a highly challenging site in a sensitive and complex historic environment. As Mr. Stewart accepted, the site is highly challenging in part because it is a tight space in which to try and accommodate such a large building in close proximity to a number of listed buildings. The appellant has consistently failed to grapple with the implications of those constraints for the appropriate scale and design of any redevelopment. That failure manifests itself in the approach taken to context. The site lies in the heart of one of London's oldest and most important conservation areas, and within a sub-area agreed to have a particularly distinguished historic character with characteristics of restrained quality and consistency. It was agreed to be one of Southwark's most significant historic streets, with a highly significant cluster of nationally important historic buildings. And yet, for the purposes of considering context and seeking to justify height and scale, the appellant effectively ignores the conservation area boundary and the highly sensitive historic site and surroundings, and looks only to the tall buildings which, with the exception of Shard Place, which we address below, all lie outside it. The consequences of this self-serving and highly selective approach to context are all too predictable. Both schemes would have no meaningful relationship to their historic context, and either tower would become a dominating and overbearing presence within the conservation area and the setting of numerous listed buildings, both in the immediate vicinity and further afield. Both would destroy the currently successful clear demarcation between the coherent and consistent historic environment and the tall buildings around London Bridge Station, and set a damaging precedent for further such development within the rest of the conservation area. The symptoms of this being too much development in the wrong place are also apparent in the distinctly uncomfortable and harmful relationship the towers would have with the Shard in a number of important viewpoints, where they are seen either in alignment or in close proximity to one another. As we explain below, there are many important viewpoints from which the Shard is either obscured or largely obscured as the station's landmark by the new towers, or in which the relationship between them is visually uneasy, as the appellant describes it. The harm would be wide-ranging and significant, both in design, townscape and heritage terms. It is telling that with limited exceptions, the harm is the same for both schemes. The 2018 scheme met widespread and consistent objections from a range of important stakeholders consulted both before and after the application was submitted. At the pre-application stage, CABE advised the appellant that the height of the proposed tower required further justification, and that its isolation from other tall buildings in the area and its proximity to the historic buildings within the conservation area clearly lead to a significant impact on the conservation area and on historic views, both locally and within the LBMF. HE advised that if the application was submitted in the form consulted upon, it would strongly object due to the serious harm that would result to the historic environment. The LPA's pre-application advice was that the height and level of harm to surrounding heritage assets was the key reason why the scheme cannot be supported by officers. Once the 2018 application was submitted, the objections received from a wide range of important stakeholders reflected those same themes and were expressed in similarly strong and unequivocal terms. The appellant's attempt to overcome the objections to the 2018 scheme with a new and markedly different design has proved to be unsuccessful. For all its myriad flaws, the appellant's own TBI-BHA continued to identify the same fundamental problems of visual dominance of the sensitive historic environment, an uncomfortable relationship to the townscape context. That was partly a result of the still very considerable height of the tower, but also because the only way that the architects were able to accommodate the client's requirement to deliver the same quantum of commercial floor space was by substantially increasing the width and massing of the tower so that it would extend along most of the site's frontage to St Thomas Street, with the bulk at floor 3 and above bulging out over the roofs of the listed Georgian Terrace. All of this has served to exacerbate the harmful and oppressive relationship between the tower and the designated heritage assets surrounding it. In the circumstances, the LPA's discouraging pre-application response to what became the 2021 scheme should have come as no surprise, nor should the strong objections subsequently received from HE, or the GLA's conclusion in its Stage 1 report that the significant width proposed, over 60 metres, does not feel proportionate or comfortable in this low-rise historic context with many designated heritage assets, and the design choice overall does not seem to be successful. Indeed, all the signals should have alerted the appellant to the fact that this was simply not a suitable site to accommodate its desired quantum of commercial floor space, and that it was necessary to take a step back and look at alternative options. Those clear and consistent signals were ignored, and the appellant pressed ahead with the scheme regardless. This time, it did so without bothering to engage with the independent design review process, either early on in the preparation of the scheme or at all, seeming to regard this as an unnecessary tick-box exercise rather than an important and obligatory step to ensure that the design quality of any tall building proposal is independently reviewed well in advance of any formal application for planning permission. Mr. Alford's evident disdain for this process seemed to stem from his belief that CABE was somehow not qualified to provide useful feedback on his designs, at least once he was no longer the chair. The subsequent belated attempt by Mr. Goddard to excuse this failure by reference to receipt of a discouraging pre-application response from the LPA is fundamentally misconceived for two reasons. If the application was therefore submitted on the assumption that it would probably need to be appealed to the Secretary of State, that has no bearing whatsoever on whether it would have been appropriate to comply with the policy obligation to undergo design review early on in the process. That policy obligation and the important public interest objectives that underlie it are no less important or applicable when a scheme is being considered on appeal. If anything, a discouraging pre-application response from the LPA on inter alia design grounds should underline the importance of going through the design review process before submission. If that process produces a response from CABE which is more positive than the LPA's initial view, it could be prayed in aid as part of the case for persuading the LPA that its initial response was wrong. If the response is negative, that would be important when deciding whether it was in fact appropriate to proceed to the stage of making an application for the emerging proposal. The upshot is that the LPA has raised objections to both schemes on essentially similar grounds. The likely reasons for refusal are the same in both cases, and are based on the adverse heritage impacts and the scale and design of the proposed development not being appropriate for the site and its surrounding context, resulting in harm to the townscape and local character. The first of those likely reasons for refusal has consistently been supported by HE, the government's principal heritage advisor, in relation to those assets which are most significantly affected. It has taken the unusual step of appearing at this inquiry as a Rule 6 party, reflecting its view as to the seriousness of the harm to the historic environment in this case. It is agreed that there is a strong statutory presumption in favour of refusal of both appeals. That is reinforced by the wide-ranging and extensive conflict with up-to-date development plan and national policy, and conflict with the development plan when considered as a whole. The policies which are infringed are policies of the highest level of importance for the purposes of the determination of these appeals. The extent and significance of the breaches are considerable, and the conflict goes to the overall thrust of the development plan. All of those are agreed to be relevant factors in forming a judgment as to whether there is compliance or not with the plan overall. Southwark is a borough that is supportive of economic growth and consequential change through appropriate development, and the development plan reflects that. In accordance with the framework and London plan, and as developed through the Southwark plan, however, the LPA is seeking to achieve good growth that is environmentally sustainable. Neither scheme warrants that description. The presumption in favour of the development plan therefore creates a further statutory presumption against a grant of planning permission in this case. It is acknowledged that there would be public benefits associated with either scheme, but the extent and level of harm and of policy conflict is nowhere close to being offset by those benefits. I then turn to the approach to new tall buildings. The Southwark plan identifies a broad area where tall buildings are expected, which includes the CAS, major town centres, opportunity area cores and action area cores. This broad area includes the appeal site. The Southwark plan also identifies specific sites that may be suitable for tall buildings and site allocations, 4 of which are in the London Bridge area. Both the London plan and the Southwark plan have detailed and stringent policy criteria for the assessment of new tall building proposals, reflecting the significant adverse impacts that can be caused at both the local and London-wide level from a poorly designed tall building in the wrong place. In providing a far more detailed set of criteria to guide the assessment of impacts, London Plan Policy D9 marks a significant change in the policy framework for the assessment of the acceptability of proposed tall buildings when compared to the approach of the London Plan 2016. It is apparent from the size and nature of the area identified by the Southwark plan that tall buildings would not be considered suitable on every site in that area. The inclusion of the Grade 1 Southwark Cathedral within the broad area exemplifies this. The Southwark plan does not attempt a fine-grain approach to tall building site suitability beyond the specific site allocations, and as Mr. Goddard accepted in cross-examination, the fact that the broad area includes sites that are obviously inappropriate needs to be borne in mind when applying the policy. A common sense approach is required, and inclusion within the broad area is very far from representing a green light for a tall building proposal. In fact, the studies and evidence base that inform the approach taken to tall buildings in the Southwark plan did not, despite Mr. Goddard's incorrect suggestion to the contrary, identify the appeal site or the wider Borough High Street conservation area as a suitable location for tall building development. Indeed, when a more fine-grained analysis was undertaken, the site was excluded from the area marked appropriate location for tall buildings, and conservation areas, including specifically this one, were described as generally unsuitable for tall building development in all relevant studies that inform the Southwark plan. The position of the Shard as the pinnacle of the London Bridge cluster also plays an important role in Southwark's approach to new tall buildings. The area vision in the Southwark plan for London Bridge explains that development should make sure that the Shard remains significantly taller and more visible than surrounding buildings as the station's landmark. As Mr. Alford accepted in cross-examination, this approach is not simply concerned with height, but also with relative visibility as the station's landmark, which requires the impact on the Shard's landmark qualities to be assessed from different locations around the area. As well as the Shard's position as the apex of the cluster concept itself is relevant when considering new tall buildings in the London Bridge area in the context of their potential impact on the setting of the Tower of London. On the assumption that further tall building development is inevitable, clustering of tall buildings to a contained area provides a means of avoiding a spread of towers and thereby limiting adverse impact on the World Heritage Site. The same underlying principle ought sensibly to apply to the London Bridge area as it applies to the City of London's eastern cluster. The same issues and impacts arise in both cases. Thus, the existence of a cluster does not mean that its continued expansion in any and all directions should be regarded as acceptable. The shape, direction, and extent of growth and the overall curation of the cluster all require careful consideration, having regard to townscape and, in particular, heritage impacts. A tower that appears to be separated from the London Bridge cluster in important views risks both increasing harm to the Tower of London World Heritage Site and introducing a spread of towers across a wider area, failing to safeguard the remaining openness of the Tower of London setting and undermining the public interest benefits of clustering. The appellant's perspective on the approach to new tall buildings in the London Bridge area has proven to be remarkably and inappropriately simplistic. Its witnesses have appeared to view the presence of the Shard, the News Building, and in particular Shard Place, as giving rise to a presumption that tall buildings would be suitable anywhere in the London Bridge area generally, and within the Borough High Street conservation area specifically. The logic of their position, if correct, would mean that it could never be said that the cluster had gone far enough in any direction, because one tall building, for example Shard Place, begets another one, the appeal site, on the basis that it is just 30 seconds or 30 metres away. It is a recipe for the incremental erosion of the area's special and distinctive character and heritage interest, and for additional cumulative harm to the OUV of the World Heritage Site. The refrain from the appellant's team throughout the inquiry was that London Bridge is and always has been a place of change, with the implication that the LPA's resistance to these particular towers pushes inappropriately against its inevitable tide of change. However, change in the form of a new tall building in a particular location in the London Bridge area is neither inevitable nor inevitably good. There has been an over-reliance on decisions made in respect of other sites, in particular Vinegar Yard and Shard Place. First, Shard Place. The 2014 committee report is not a statement of policy and should not be treated as such. It assesses a different proposal on a different site by reference to the previous development plan. The two sites are significantly different in ways that the mere number of seconds or metres between them does not reflect. This over-reliance on the grant of permission for Shard Place was not just apparent in the manner in which the appellant's case was presented at the inquiry, but also in their application materials. Notably, the BHA for the 2018 scheme describes the grant of consent for Shard Place as sending a clear message that there is a place for modern development of scale in the conservation area. This represents a significant failure to consider each decision on its own facts. Then Vinegar Yard. The appellant is keen to rely on the aspects of the GLA's representation hearing report, also not a policy document, that they felt supported their case. Again, however, the appellant's case fails to acknowledge key differences between that proposal and the two appeal schemes, where the former met development plan policy requirements and the latter do not. For example, in respect to the requirement under London Plan Policy D9D that proposals resulting in harm to heritage assets demonstrate that alternatives have been explored, GLA officers were satisfied that this had been shown in relation to Vinegar Yard. By contrast, the best that Mr. Goddard could come up with in respect of alternatives being explored in this case was the fact that there were two alternative schemes, both of which, even on Mr. Stewart's evidence, give rise to effectively the same heritage harms. The over-reliance on previous decisions in cases with materially different facts and emphasis on the suggested inevitability of adding another layer of history to London Bridge through further tall building development reflects a highly simplistic and crude approach. It effectively seeks to sidestep the detailed and recently enhanced scrutiny that the development plan rightly expects of buildings that have the potential to give rise to significant and wide-reaching impacts. Next, a point of landmark significance. The first criterion of policy P17 of the Southwark Plan is the locational requirement that tall buildings must be located at a point of landmark significance, defined as being where a number of important routes converge, where there is a concentration of activity, and which is or will be the focus of views from several directions. These factors are concerned with the site and its existing status rather than on the nature or impacts of the tall building that is proposed. It is common ground that not every site within the broad designated area can be of landmark significance. The appellant has long been aware that compliance with this policy requirement is problematic here. That much is plain from its decision to instruct DP9 to argue for its removal from the draft Southwark Plan Tall Buildings Policy. DP9 argued that this criterion did not recognise the role that tall buildings can play in creating new areas of townscape significance and stimulating regeneration, but those arguments did not prove persuasive, and the requirement has become part of the development plan. Mr. Goddard's attempt to suggest in cross-examination that this representation did not imply any concern as to the implications of the proposed criterion for the soon-to-be submitted 2018 scheme, as merely directed towards preventing the policy from being overly prescriptive, is not credible. The only sensible reason for the appellant to pay DP9 to make those representations was to seek to influence Southwark Plan policies so that they would be more favourable to the 2018 scheme, which Mr. Goddard did accept. This was not an exercise in altruism. In simple terms, if the appellant and its team of advisors had thought the application of this criterion would tend to support the suitability of the site for a tall building, they would not have sought its removal. Against that background, it is notable that none of the appellant's witnesses addressed the application of the Southwark Plan's definition of landmark significance in their written evidence. Instead, Mr. Alford simply asserted that the site was at a point of landmark significance, and Mr. Goddard, without more, relied upon that assertion. The first attempts at an explanation were made in oral evidence. Dealing with each aspect of the definition in turn, the site is not located where a number of important routes converge. Whereas Borough High Street is an important route, in the context of surrounding major streets, including Tooley Street, St Thomas Street is a more local route. In any event, and importantly, the appeal site is not located at a point at which important routes converge. Mr. Alford initially accepted that the point of convergence between Borough High Street and St Thomas Street is Barclays Bank. However, when, presumably, he realised the implication of this concession, he then claimed that the point of convergence in fact encompassed a far wider area along Borough High Street and east along St Thomas Street. The point of convergence was said to extend so far along St Thomas Street that a person standing outside Keats' house was still at a point where important routes converge. That was an absurd position to adopt. Mr. Goddard's later bite at the cherry was similarly unpersuasive. He claimed that the new entrance to London Bridge Underground Station would result in the site being at the point at which important routes converge, entirely missing the point that the focus of the policy is on the existing position. Further, even if it is accepted that a large run of St Thomas Street is located at a point at which important routes converge, the location of the towers would not be on St Thomas Street, but rather in a backland location with no street frontage. The site plainly is not where there is a concentration of activity. Mr. Alford's position was that so long as people walk past the site to access major attractors of footfall such as the Shard or London Bridge Station, the site itself qualifies as a location where there is a concentration of activity. He accepted that this would make every building along Borough High Street and the western end of St Thomas Street a location where there is a concentration of activity. That, again, is an absurd approach to the policy requirement. It is the destination to which people are moving that represents the concentration of activity, and not the places they pass on their way to it. The site generates a modest level of footfall from its existing use, but it cannot properly be described as representing a concentration of activity in any meaningful sense. The status of the appeal site can usefully be contrasted with that of the Shard Place and the News Building, all of which sit on top of or immediately adjacent to major access points to London Bridge Underground and Rail Station, and in the case of the News Building, the bus station, on all of which are highs of activity associated with the use of the station. There is no tension between these three buildings being located at a point of landmark significance and the appeal site not. As to the final aspect of the definition, Mr. Alford agreed in cross-examination that the appeal site is not currently the focus of views. He also accepted that if you put a big enough building on any site, it is likely to become a focus of views to some extent, but that this does not tell you anything about whether the site itself is located at a point of landmark significance. He was right to make these concessions. Miss Adams explained that the absence of tall buildings in the location of the appeal site provides important openness between the London Bridge cluster and the historic area around Southwark Cathedral in views from London Bridge. The absence of landmark status of the appeal site allows focus to appropriately be placed on views of true landmark locations such as the Shard and Southwark Cathedral. The upshot of the appellant's approach to the landmark significance requirement is that on Mr. Alford's analysis, any site along St Thomas Street or Borough High Street could be said to be located at a point of landmark significance. That is not a realistic approach to the clear policy criteria and serves only to emphasise the inability of the site on a proper analysis to meet any of the aspects of the definition. The appellant's concerns about meeting this criterion back in 2018 were well founded. The proposed towers would clearly not be located at a point of landmark significance and thus conflict with the first criterion of policy P17. So I then turn to the effect of the appeal proposals on the significance of designated heritage assets. Start with introduction. In closing, we don't seek to address the impact on each of the designated heritage assets covered by Dr. Barker-Mill's written evidence, but instead focus our attention on those which were addressed in the oral evidence of the LPA, HE and the appellant, and I've listed those below. The impact on the other designated heritage assets that would be harmed should not, however, be treated as an unimportant or peripheral issue. Those impacts are identified and assessed in section 9 of Dr. Barker-Mill's proof of evidence, which we commend to you, Madam, and the Secretary of State, as a fair and robust assessment of where harm occurs and the extent of the harm. Where harm occurs, it is to be given great weight, with a specific level of weight reflecting both the extent of the harm and the significance of the assets in each case. In these appeals, it is not only the weight ascribed to the harm to individual assets that matters, it is also the extent of and weight to be given to the collective harm. Many of the designated heritage assets that will be adversely affected in this case are not only important in their own right, they are also important in the role they play as part of the special character and appearance of the Borough High Street conservation area. The number of individual designated assets within the conservation area that are adversely affected therefore reflects and is consistent with the widespread nature of the adverse impact on its special qualities. I then have a section on general approach and policy points. The appellant's flawed and incomplete approach to the assessment of heritage impacts has been problematic from the outset. Significant concerns about the methodology and transparency of the assessments used in the BHA were raised during the review of the ES by the LPA's EIA consultants, LUC, in respect of both applications. These are not new points. The appellant has had notice of them for years, and yet the same errors and omissions are reflected in the evidence to this inquiry. Dr. Barker-Mills summarised his concerns in his proof of evidence and gave further evidence on the errors in approach, including a worked example and evidence in chief. That evidence was clear, compelling, and obviously right. The cross-examination of Mr. Stewart then served to demonstrate how those substantial gaps and methodological errors in the analysis gave rise to some of the more surprising conclusions reached in the appellant's assessment. It's also been instructive to observe and consider some of the propositions about approach that have been put in cross-examination of Dr. Barker-Mills and Mr. Young. They too reveal much about the appellant's reluctance to acknowledge and then address the true scale of impact that would arise in this case. Fortunately, a good deal of helpful common ground on the approach has now been established through cross-examination of Mr. Stewart. Madam, it's at this point that I'm going to take some matters as read. But as you'll see, I've dealt with matters established as common ground and submissions on these subjects in the following pages. So I deal with setting, I deal then with calibration of harm, cumulative harm and precedent, the juxtaposition of old and new, development plan policy approach to protecting the World Heritage Site, and architectural quality as a factor in potentially reducing heritage harm. I've set those matters out. Much of that is recording of what was conceded in cross-examination, make clear where that's the case, but I don't propose to read those out. They're there for your benefit. And so I'm going to focus in my oral submissions from page 23 on the assets that have been dealt with in oral evidence. So picking up the text at paragraph 57, there are two preliminary points to be made about the evidence relating to the impacts on the heritage assets in this case. The first is to do with the images of the proposed towers. When considering the impact of the proposed towers by reference to sub-area 4 of the conservation area and the settings of those listed buildings closest to them, there is a notable lacuna in the suite of images, both still and moving, produced by the appellant. The appellant has produced a full-height image of the 2021 scheme as seen from St Thomas Street outside the Shard looking west, but no equivalent full-height image for the 2018 scheme. In cross-examination of Mr Stewart, it was established that there was no technical reason why such an image was not or could not have been produced. The appellant just chose not to do so. The image for the 2018 scheme only extends as far as about level 16, approximately 65 metres AOD, some 40 metres or more below what is shown for the 2021 scheme, and almost 80 metres less than its full height of 144 metres AOD. Mr Stewart confirmed that if you, madam, want to get an idea of what the full height of the 2018 tower would look like from ground level looking west on St Thomas Street, the appellant has not provided any illustrative material to show this. The LPA, through Miss Adams, has sought to fill the gap, and it has agreed that her amended figure 2 is the best image that you, madam, have for this purpose. That is a remarkable state of affairs, having regard to the technology available to the appellant and to the following points. First, the proposal is to erect a 144-metre high tower in the middle of a low-rise conservation area and very close to many listed buildings. Harm is acknowledged in the view from St Thomas Street and to Guy's Hospital through development in its setting. And in correspondence, the LPA asked the appellant to provide a fully rendered version if it did not consider Miss Adams' amended image to be sufficiently accurate or representative to be relied upon by you. It is compounded by the fact that in neither of the walkthrough videos produced for the purposes of the inquiry does the viewer on St Thomas Street look up to take in the building as a whole for either scheme and therefore enable the effect of the scale of the building to be appreciated. Why is the appellant so coy? Its TVI-BHA acknowledges the view from St Thomas Street to be one in which the degree to which the development dominates the existing street scene, part of the conservation area, comprised largely of listed buildings, from this viewpoint is considerable, and the coherent quality of the existing view is disrupted. In the circumstances, the most likely explanation would seem to be a reluctance to allow the full magnitude of that adverse impact of major significance to be appreciated by the decision maker for fear of what that might lead to. Second preliminary point concerns the evidence of Dr. Barker-Mills. Dr. Barker-Mills' evidence was notable for the care he had taken to ensure that his assessment was clearly structured to follow the approach espoused in HE guidance and to be transparent. That is important because it allows others, including you, madam, to understand what informs each stage of the assessment, where professional judgment has been exercised, and the basis for those judgments. In those circumstances, it is remarkable how little challenge there was, either in rebuttal, cross-examination of Dr. Barker-Mills, or examination in chief of Mr. Stewart, to the detail of his assessment. We therefore commend his written and oral evidence to you and the Secretary of State as being robust, credible, and reliable. So I then turn to the first of the assets, which is the Borough High Street Conservation Area. Dr. Barker-Mills assesses the impact on the conservation area in his proof of evidence at the paragraphs that I've given, as supplemented by his evidence in chief. That shows that there would be less than substantial harm to the conservation area above the middle and towards the upper end of the range. His evidence on this matter has the benefit of consistency with the views of Mr. Young on behalf of HE, whose own evidence displays an impressive, detailed understanding of this highly valuable conservation area. The same cannot be said of the appellant's evidence. Mr. Stewart is a lone voice in arguing that the impact on the conservation area would be to enhance it, and the justification for that conclusion did not withstand scrutiny and cross-examination. His assessment acknowledged unspecified harm, but then suggested this was offset by the many positive qualities of the development, which turned out to have nothing to do with the special qualities for which the conservation area has been designated. The outcome of the assessment he has undertaken is simply not credible, as even a cursory glance through the TVI-BHA images of the proposed towers, taken from important viewpoints within the conservation area, would reveal. Dr. Barker-Mills was right to say that it is simply not accurate to present this as a reasonable difference of professional judgment about effects. The assessment is methodologically flawed and incorporates irrelevant considerations which are critical to the conclusions reached. No reliance can be placed on it as a result. You, madam, will of course reach your own expert conclusions as to whether there is harm, and if so, the extent and significance of it. In doing so, it can be noted that Mr. Stewart did not dispute that the conservation area appraisal represented a fair encapsulation of the special qualities that justified designation, and that you and the Secretary of State should use it for the purposes described in paragraph 111. There are three further points we wish to make about the approach to the assessment of harm to the conservation area. As with the approach to heritage assets generally, the key point is not whether some aspects of the conservation area are left untouched, but the importance of what would be affected to its significance. In this case, it is agreed that when assessing the impact on the conservation area, it's important to have in mind the distinct character of the sub-areas as well as the overall identity of the conservation area as a whole. In any event, it's agreed that whilst the towers will be situated in the heart of sub-area 4, they will also be very apparent in views from the other three sub-areas. That reflects the relatively low heights of buildings in the conservation area, the position of the appeal site within it, and the height of the proposed towers. Sub-area 4 is agreed to have its own distinct character, with the quality and consistency of the buildings and the formality of the hospital buildings clearly being key to the character and appearance of this sub-area. It is also agreed to represent a marked change in character from the High Street, to already possess a listed landmark feature, which is consistent in character and appearance with the other listed buildings in this part of the conservation area, and to have a special identity in which the completeness and coherence of the elements in this part of St Thomas Street is of special note. The appellant's evidence and approach is remarkably and inappropriately dismissive of this very important and historic conservation area. The variety within the conservation area as a whole, arising from its unusual and highly valuable time depth, is treated as somehow making it less sensitive to the impact of tall buildings. Why that is believed to be the case is never properly explained, presumably because there isn't a proper basis for it. The CAA makes clear that the overall identity of the conservation area is as much to do with scale and form as other factors. These special qualities make it more rather than less sensitive to the impact of new development, which is entirely, indeed dramatically, out of keeping in both scale and form. The yard leading off Borough High Street, features of obvious and acknowledged importance to its character and appearance, are treated by the architect designing the scheme as places of misery, a problem to be addressed rather than an essential and valuable feature of the historic grain of the townscape, recognised both in the CAA and the Southwark Plan's area vision. The appellant has focused relentlessly on the ability to see tall buildings from within the conservation area, and as we have already explained, the LPA's decision in 2014 to approve Shard Place on the very edge of the conservation area, right next to the Shard itself, as effectively allowing for open season in terms of erecting towers further into the conservation area. The first of those matters fails to recognise the importance and implications of the conservation area boundary. We've responded to the second of those matters in the introductory part of this closing, which we don't repeat here. Having regard to the importance of the asset and the extent of harm, very significant weight should attach to the harm to the conservation area. Then Guy's Hospital. Dr. Barker-Mills assesses the impact of Guy's Hospital in his proof at the paragraphs identified as supplemented in evidence in chief. His evidence explains why there would be less than substantial harm to this Grade 2 star listed building above the middle and towards the upper end of the range. Importantly, his assessment is also consistent with the views of Mr. Young on behalf of HE. On behalf of the appellant, Mr. Stewart acknowledges less than substantial harm will be caused, though he has seriously underestimated the level of that harm by identifying it as minor. His calibration of harm is unreliable, as illustrated by the following points. His assessment plainly relies on the existence of other tall buildings within the setting of the listed building as serving to limit the extent of harm, rather than giving rise to existing harm to which the proposed tower would add cumulatively. He agreed that his assessment did not in fact assess whether the impact of these modern elements is positive, neutral or negative. When asked in cross-examination to express a view as to whether Guy's Hospital Tower was a negative element in the setting, he acknowledged that it was, but concluded that it too had a minor effect. That is helpful because it establishes common ground that there is a need to consider cumulative harm from tall buildings in this instance, and it allows you, madam, to get a sense on site of quite what Mr. Stewart regards as a minor effect. In cross-examination, it became apparent that the level of harm to this particular listed building was regarded by Mr. Stewart as being ameliorated by what he had described as tangible long-term benefits to the setting of this listed building, but which he ultimately accepted not to be relevant either to its heritage significance nor the ability to appreciate its significance. To say the least, that is a surprising and elementary error to make when assessing the extent of harm to a Grade 2 star listed building, and symptomatic of the general lack of rigour, robustness and transparency in the appellant's assessment. Having regard to the importance of the asset and the extent of harm, very significant weight should attach to the harm to Guy's Hospital. Then the St Thomas Street listed buildings. Dr. Barker Mills assesses the impact of these listed buildings at his proof of evidence in the paragraphs given. I've identified there also where he pitches the harm in terms of the range, as supplemented in his examination in chief. His oral evidence also included an examination of how the impact on these buildings was assessed in the appellant's BHA, by way of a worked example of how that assessment had failed to follow key parts of the HE recommended stepped approach and could not be relied upon. That evidence was clear and compelling, illustrating the points made in section 10 of his evidence, and the appellant has offered no satisfactory answer to it. Having regard to the importance of the assets and the extent of harm, significant weight should attach to the harm to these listed buildings. Then Southwark Cathedral. The harm to this Grade 1 listed building is assessed in Dr. Barker Mills' proof, paragraphs given, supplemented in evidence in chief. For the reasons he gives, the level of less than substantial harm will be above the middle and towards the upper end of the scale. His assessment is broadly consistent with that of Mr. Young on behalf of HE, who characterises the level of harm as high. Mr. Stewart acknowledges less than substantial harm would be caused, though he has seriously underestimated the level of that harm by identifying it belatedly as minor. His calibration of harm is unreliable, as exemplified in the following points. He's failed adequately to consider the issue of cumulative harm. In cross-examination, Mr. Stewart accepted there was no assessment in the BHA of whether the presence of tall buildings such as Guy's Hospital Tower in the setting of the cathedrals where it can be seen is positive, negative or neutral. He also accepted the Guy's Hospital Tower plainly is a negative element of the setting. He also acknowledged that the Shard has an unsatisfactory relationship with the cathedral. Where the setting already features negative distracting elements in the form of tall buildings, adding the appeal proposals is agreed to give rise to cumulative harm. The appellant has not assessed cumulative harm, and indeed appears positively to rely on the presence of tall buildings in the existing view as justification for adding more. A related flaw in Mr. Stewart's assessment is that it does not sufficiently acknowledge the importance and value either of the view of the cathedral from the north across London Bridge or the views immediately in front of the cathedral, where it's currently seen against clear sky without tall buildings in the background. So far as the latter views are concerned, Mr. Stewart accepted that these are views which at present offer a particularly good opportunity to appreciate the form, silhouette and external architecture of the cathedral. The effect of the development will be to introduce a tall building behind the cathedral in views where it's currently seen against clear sky. That is agreed to be harmful. Where Mr. Stewart's assessment goes wrong, however, is to treat as harmful only those instances where the proposed tower would be seen directly behind the cathedral's tower. Where the two are seen alongside one another, Mr. Stewart assumes that there is no longer any adverse impact, either on the significance of the cathedral as derived from the setting or on the ability to appreciate that significance. That is an inappropriately narrow and restrictive approach, taking no account of the existence and extent of distraction and visual competition where the two towers are seen alongside one another. Having regard to the importance of the asset and the extent of harm, very significant weight should attach to the harm to Southwark Cathedral. Then the Tower of London. Dr. Barker Mills assesses the harm to the Tower of London in his proof at the paragraphs given, as was supplemented in evidence in chief. For the reasons he gives, the level of less than substantial harm would be just below the middle of the range for the 2018 scheme and at the low end of the range for the 2021 scheme. His assessment is broadly consistent with that of Mr. Young on behalf of HE, albeit a notch higher in the case of the 2018 scheme. Mr. Young concludes that there would be less than substantial harm in both cases, characterising the level as low in both instances. Mr. Stewart concludes there would be no harm at all for either scheme. Whilst he's wrong in respect of both schemes, his conclusion in respect to the 2018 scheme is simply not credible. The following points are of particular relevance when forming a view on this matter. Dr. Barker-Mill's assessment of the extent to which the relevant attributes rely on setting is uncontroversial. Mr. Stewart confirmed that whereas in his assessment it was noted that the tower would be visible as one of a number of tall buildings and would add to the grouping, he'd given no consideration of whether that existing grouping gave rise to harm. Mr. Stewart accepted that the approach taken in the assessment was to refer to and endorse the findings of the inspector who held the inquiry into the Shard, incorporating those findings wholesale into the assessment. It is plain from the subsequent events recorded in the Tulip decision and the decision itself that those findings cannot be relied on as a guide to what is now to be considered acceptable. The government has acknowledged harm was caused by the Shard, and the policy has subsequently been significantly tightened in order to address the evident ineffectiveness of the previous policies to protect the OUV of London's World Heritage Sites. If you, Madam, and the Secretary of State conclude that the visibility of the 2018 scheme, cumulatively with other tall buildings, would mean that attention would be distracted from the buildings within the inner ward, or the proposals would compete for attention with those buildings, that would constitute harm. The Tower of London is a heritage asset of universal and international importance, among the most important cultural heritage sites in the world, and a key feature of London's identity as a world city. It is agreed, and the government has made clear, that harm to its OUV should be given the maximum weight possible in decision-making. It's also agreed that if you, Madam, and the Secretary of State were to find that there would be less than substantial harm to this asset, it would be appropriate to attach the maximum possible weight to this harm and to conclude that it gives rise to a conflict with development plan policy. Having regard to the importance of the asset and the extent of harm, very significant weight should attach to the harm to the Tower of London caused by the 2018 scheme, and significant weight should attach to the harm caused by the 2021 scheme. I then deal with St Paul's Cathedral, but I won't read that out because we didn't deal with it in our own oral evidence, but you have the position there set out. I then move on to heritage benefits. These are acknowledged. There are acknowledged to be some heritage benefits that would arise in the proposed works to the Grade 2 listed terrace. As Dr. Barker-Mills has explained, the effective reversal of the previous opening up of the interiors and restoration of the planned form would be a heritage benefit. In just the same way as any harm, no matter how modest, to the heritage significance of the designated heritage asset should be given considerable importance and weight, it's accepted that works which provide a benefit to that heritage significance, no matter how modest, should also be given considerable importance and weight. That's the appropriate starting point, but as the Court of Appeal has made clear in Bramshill, that does not predetermine the appropriate amount of weight to be given to the conservation of the heritage asset in a particular case. Resolving that question is left to the decision maker as a matter of planning judgment on the facts of the case, bearing in mind the relevant case law, including Lord Justice Sullivan's observations about considerable importance and weight in Barnwell Manor. Adopting that approach, plainly not all benefits, just as not all harms, will have the same weight in the planning balance. Dr. Barker-Mills gave oral evidence as to why he did not regard the benefit to be particularly significant in the context of the schemes as a whole, and his view and reasoning was echoed in the views of Mr. Young on behalf of HE. These are benefits, but their relative importance in the overall planning balance should inevitably reflect the relatively modest level of heritage benefit that they will deliver. On the evidence the inquiry has heard, it is plain that the other claimed heritage benefits are nothing of the kind. I then won't read out the part on listed building consent applications. It simply reflects the note that we put in. So in conclusion, when the adverse effects on heritage assets are considered as a whole, their collective weight must be very substantial indeed. Those effects give rise to a strong statutory presumption in favour of dismissing the appeals and to significant direct conflict with development plan policies of the highest importance for the determination of these appeals. As we explained below, the benefits that the schemes deliver, including the modest heritage benefits, would come nowhere near outweighing that harm and overcoming the resulting statutory and policy presumptions. So I then turn to the second main issue, the effect of the appeal proposals on the character and appearance of the area with regard to urban design, townscape, architectural quality and public realm. The Council's evidence on these issues is in Miss Adams' evidence, supplemented by her evidence in chief. The policy context is summarised in her proof of evidence. There are inevitable overlaps between this issue and the heritage impacts, not least because so much of the surrounding townscape is of heritage significance. These issues are also addressed under the headings The Approach to New Tall Buildings and The Point of Landmark Significance in the introductory section above. So first of all, approach. It's plain from Mr. Alford's oral evidence that the quantum of deliverable commercial floor space that would be achievable through a tall building proposal was a key driver of the brief. This driver applied to both schemes, and when asked whether he had suggested to the appellant that they consider reducing their ambitions in respect to the quantum of development in order to allow the drawbacks of the 2018 scheme to be avoided, Mr. Alford said that he had not, because the brief had been fixed by 2018 and he understood that it was on the cusp of being viable. The brief for the 2021 scheme thus encompassed the same broad overall level of floor space, with a reduction of mass in the sky and increase within the city, along with the removal of retail space and the introduction of a fully on-site servicing arrangement. The substantial increase in mass within the city was said by Mr. Alford to be directed towards appeasing Southwark Cathedral's Fabric Advisory Committee and removing one of the barriers to the LPM making a favourable decision in respect to the project. It was not a meaningful attempt to respond to and resolve the much wider concerns raised by the LPA and many others about the impact of a tall building on the site in the more immediate context of Guy's Hospital, Sub-Area 4 of the Conservation Area, and the listed buildings on St Thomas Street, or in respect of any of the other local heritage assets impacted. The appellant's commercial imperative has led to a blinkered approach to the design process and to substantial adverse impacts on the design outcomes for both schemes. Mr. Alford's views as to the success of the design of each scheme must be approached with caution. It's unsurprising and uncontroversial that he's unable to be impartial or independent when giving advice in relation to evidence in relation to the schemes that his practice has designed. His particular role as a scheme architect and the inevitable positive view he takes of the design outcomes means that the weight that should be attached to his evidence is diminished. By contrast, Miss Adams was an independent and impartial witness with no prior involvement in the schemes. Notwithstanding the obvious distinction in their status at the inquiry, Mr. Alford took the opportunity in response to cross-examination to cast aspersions on Miss Adams' expertise, claiming in particular that she does not have any experience in designing office space. His criticism is entirely unfounded and unfair. It's unfounded because Miss Adams' practice was a very recent winner of the New London Architecture Award for Best New Workplace. That's reflective of the breadth and extent of the relevant experience that she is able to bring to bear in her expert evidence, as set out in section 1 of her proof. It was also unfair because Miss Adams' expertise was quite rightly not challenged in the appellant's rebuttal proof of evidence, nor when she was being cross-examined. An expert witness is to be criticised in a public inquiry as not holding sufficient experience or expertise to provide an expert opinion. The appropriate approach is to put that to the witness directly to allow them a fair opportunity to respond. Miss Adams took great care in her evidence, both written and oral, to analyse and explain the existing context at and in the vicinity of the appeal site and the design and townscape impacts of each scheme. She explained her views as to the success of the design of the schemes in a clear and methodical manner by reference to the general design policies and, notably, the detailed criteria set by the London Plan and Southwark Plan tall buildings policies. Her evidence was credible, balanced and fair, and we commend it to you, Madam the Secretary of State. The decision by the appellant to proceed with a tall building was made in 2014-2015 before any engagement with stakeholders or notably any input from Mr. Stewart on townscape and heritage matters. When the appellant's team did engage with stakeholders in respect of the schemes and their impact, Mr. Alford's general approach was not to pay heed to and seek to respond to concerns raised. His yardstick for a successful design was whether he considered the schemes to be delightful, and on the basis of his responses to questions in cross-examination, he did not appear to be terribly interested in, let alone respectful of, the views of others, including H.G. and Cabe. This lack of willingness to pay proper heed to the views of others seems to have stemmed principally from his opinion on the approach to or quality of the advice that he received. As already explained, he viewed the quality of Cabe's advice as being insufficient to justify a design review of the 2021 scheme. In respect of H.G., he considered them to not be sufficiently progressive to warrant taking proper account of and responding to their clearly expressed concerns. This dismissive approach to the considered views of stakeholders reflected a striking lack of humility in relation to the development of this plainly sensitive site. The dismissive approach did not stop there. It was instructive and somewhat surprising to hear Mr. Alford disagreeing so significantly with the views of Mr. Stewart as to the townscape and heritage impacts of his proposed towers. Mr. Alford at least seemed to acknowledge Mr. Stewart's view was a correct technical analysis, which ironically it was not, but made no attempt to respond to and address the adverse impacts he'd identified in the TVI BHA. Given the nature and scale of the impacts, even as identified by Mr. Stewart, this finding should have set alarm bells ringing. The TVI BHA identified a number of problematic relationships between the towers, the Shard, the conservation area, and the immediate street scene, from a range of viewpoints within the conservation area. In respect of the 2018 scheme, to name but a few, the assessment identifies a visually uneasy conjunction with the Shard in the view from St Saviour's War Memorial, and a noticeable shift in the balance between historic foreground and modern background, a noticeably greater domination of the historic foreground by modern background than is the case with the views existing from Southwark Street, Stony Street, considerable domination by the development of the existing street scene, disruption to the coherent quality of the view from St Thomas Street, London Bridge Street, and a greater distraction to the viewer than the Shard from the West Wing, Guy's West Wing quad panorama. It's striking that Mr. Stewart reached the same conclusions in respect of townscape impacts for the same set of views for the 2021 scheme. It was established in cross-examination that Mr. Alford considered that Mr. Stewart's analysis was likely to be the same if a third option for a tall building would be proposed with similar floor space. This, we submit, rather suggests the site is fundamentally unsuitable for a tall building, either at all or certainly with the quantum of floor space sought by the appellant. As for heritage input, there is no dispute that reliable and robust input regarding the effects of particular design options on heritage assets is a very important design input for a highly sensitive site such as the appeal site. That's consistent with a development plan which expects design to respond to a site's historic context. As the inspector and the TULIP recognise, an unsympathetic response to the historical context is relevant to whether a scheme is of good or, as required here, exemplary design. Given that Mr. Stewart was not instructed until after Mr. Alford and the client had settled on a tall building as the way forward for the project, and given that Mr. Stewart was unable to point to anything specific in either scheme that had changed as a result of his heritage advice, it appears as though thorough and careful assessment of the historic context did not inform the main elements of the design in any meaningful way. The outcome is a design that does not positively respond to the site's historic context, and this not only leads to a conflict with heritage policies of the development plan, but also those applying specifically to design. Then height, scale and massing. Ms Adams assesses the adverse impacts of the design of the schemes in terms of the height, scale and massing in her proof of evidence of the paragraphs we've given. Good design does not exist in a vacuum when it comes to placemaking and planning. Mr. Alford accepted that a proposal that fails to respond positively to local context and the wider London landscape would fail to accord with the development plan. Yet, what he has designed, even after 2 attempts, is entirely at odds with the immediate context and would be harmful to the wider London landscape. As became clear at the inquiry, the height, scale and massing of both schemes are driven not by context, but by client requirements, commercial considerations, and by a process that has eschewed the input of assessment regarding heritage and townscape impact and the advice of many stakeholders. The result is 2 disruptive and discordant towers that are disproportionate to the size and significance of the site and the scale and character of the surrounding townscape. Next, architectural quality. The London plan and Southwark plan require tall building design to be exemplary. Ms Adams' brief explains why neither scheme meets this standard. The paragraphs we give. She assesses each building's base, middle and top in accordance with the approach set out by policy D9. Good design is about much more than the architectural expression of a building. As Ms Adams' written evidence explains, architectural quality is not a simple phenomenon confined to form making or composition, and instead requires success on a number of levels, including achieving high quality placemaking and being responsive and sensitive to context. Design quality should not be assessed in isolation from a building setting or its impact on adjacent or associated existing buildings. The appellant's approach has sought to focus on the quality of the appearance of the building, divorced from its context. The view from Guy's Hospital looking west from the North Quad exemplifies the folly of the appellant's approach. However good or exemplary one might find the architectural expression of either or both of the schemes to be in isolation, the view of the towers from this location demonstrating why scale, siting, height and massing are highly relevant factors when judging the quality of a design in context. The result of the juxtaposition of Guy's Hospital North Quad and the schemes, with the leap in scale of the towers and their very awkward relationship with the classical formality of the historic building in the foreground, is extremely unfortunate. The same concerns arise in respect to the relationship between the towers and the Georgian terrace on St Thomas Street. Miss Adams aptly described that the terrace would become subservient to the tower and would consequently reduce the terrace to a base for the modern towers or a footnote. Moreover, leaving to one side the incongruous juxtaposition created by the tower's scale, height and mass, the appearance of the towers would serve to exacerbate that harm when considered in context. The warehouse and large-scale infrastructure references borrowed by the appellant from locations outside of sub-area 4 of the conservation area, and for the 2021 scheme from an entirely different conservation area, bear no relationship to the materiality of the existing London Bridge cluster that the appellant is seeking to align their schemes with, but they also jar significantly with the consistent formal Georgian architecture of St Thomas Street, and as we've already explained, the neoclassical approach taken to Guy's Hospital. It was suggested by Mr Stewart that using brick, the predominant material in sub-area 4, would have been a peculiar choice for tall buildings on the appeal site, because it would have undermined the differentiation between old and new. It was ironic then that in re-examination he was taken to the National Design Guide, where a good practice example of a tall building that sits well in its context, which is in fact located in Southwark, uses brick. Not suggested that brick is the only acceptable solution for a tall building on the appeal site or in Southwark, but rather that a necessary component of good design is an architectural expression that is an appropriate response to the specific context of the appeal site, something which cannot properly be said of either scheme. And then public realm. The quality of the public realm for each scheme at ground level has been significantly compromised by the commercial imperative to maintain a particular quantum of floor space. For each scheme, the public realm is ungenerous, lacking a sense of openness, overshadowed and dominated by tall buildings, and unlikely to be attractive to users as a place to dwell. Miss Adams' proof explains the inadequacies of the public realm, the paragraphs we've identified. The public realm will receive little sunlight for most of the year. The mainly sunlit images produced to illustrate it belie the written evidence that is before the decision maker. The 2018 scheme's landscape strategy describes most of the public realm as being in light to deep shade during most of the day for most of the year. The GIA appendix to Mr Goddard's rebuttal evidence shows that a large proportion of the public realm will be non-compliant with the BRE guidelines, and it suggests that the entrance from St Thomas Street is not considered to have a specific requirement for sunlight, because rather than being an amenity space, it is instead simply a point of entry. This is despite Mr Alford seeking to rely on it as providing a pocket park of amenity space. The 2021 scheme fares worse. The increase in massing of that scheme results in a decrease in public realm from approximately 1,305 square metres in the 2018 scheme to 1,136 square metres, of which 54% would be under cover. As Mr Alford accepted, this would result in reduced daylight, sunlight and views of the sky in that scheme. That's reflected in the 2021 landscape strategy, which describes most of the outdoor areas that are not covered being in part shade for most of the day during most of the year, and the GIA appendix to Mr Gullard's rebuttal, which shows most of the courtyard outside the new London Bridge Underground station entrance as failing to comply with BRE guidelines. It's not simply the increased mass of the tower that has an adverse impact on the public realm in the 21 scheme. It's also compromised by the arrangement for on-site servicing. This is due to a number of factors. The scheme does not include a link from the entrance square to the tower on St Thomas Street through Beak Alley to King's Head Yard due to the presence of the servicing yard. This means that pedestrians wishing to access Beak Alley need to use an access that is shared with the servicing yard, which will be used by HGVs and refuse vehicles. It means there will be two substantial gaps in the building line and the active frontage on St Thomas Street, one for the entrance to the tower and another for the servicing yard and access to Beak Alley, resulting in a greater loss of active frontage on St Thomas Street. The 2018 scheme has active frontages on Beak Alley, with retail units and a gym entrance as well as a shop at the back of Keats House. Those important features are absent in the 21 scheme, which therefore has no passive surveillance down Beak Alley. Instead, it becomes an alleyway with dead frontages, shielding the loading bay behind. It's surely no coincidence that the appellant chose not to show the pedestrian access shared with the servicing access through to the blank frontages of Beak Yard in the 21 video walkthrough, in contrast to the 2018 scheme where every aspect of the public realm, including Beak Alley, was shown. There is no dispute between the parties that the 21 public realm will be materially less attractive and appealing to pedestrians when compared to the 2018 scheme. Finally, there is a distinct reason to be concerned about the success of the 2018 public realm. It emerged during the inquiry that the substantial reduction in retail provision in the 21 scheme was a change to the brief made by the client to reflect concerns about the likely success of retail in the current climate, linked to the rise in online retail and decline in the bricks and mortar version. When Mr. Alford was asked whether he had considered in his written evidence the implications of concerns about whether retail in this location could be successful for the success of the public realm in the 2018 scheme, he admitted he had not, and suggested the appellant would cross-subsidise the retail, and he envisaged that GPE would curate the unit's occupancy so that it would be successful. As Mr. Goddard accepted, neither appeal seeks a personal permission for the appellant. There's no guarantee the appellant would deliver the schemes themselves. We say more about this in relation to the benefits below. The identity of the appellant is irrelevant to the decision that must be made now as to the likely success or otherwise of the public realm. The lack of confidence in the retail provision in the 2018 scheme casts significant doubts on the likely success of the public realm, even leaving aside its physical inadequacies. Then impact on townscape and views. Miss Adams' brief explains the adverse impact of the schemes on townscape in respect of local, borough and strategic views. Paragraphs we identify, impact on LBMF views addressed in Dr. Barker Mill's evidence, the paragraphs we identify there. The requirement in AB 11 of the Southwark Plan for the Shard to remain significantly taller and more visible than the surrounding buildings was a further policy criterion that the appellant sought to have excised from the plan through its local plan representations. Again, the only credible explanation for seeking to remove this criterion is that the appellant and its professional advisors were concerned about the impact, if adopted, on its ambitions for the site. The appellant was plainly right to be concerned in a context in which the townscape input received from Mr. Stewart identified an uncomfortable and uneasy relationship with the Shard, and one in which views of it would be obscured and the proposed tower would become the new focal point from a number of important viewpoints, as we've explained already. Rather than face up to this issue and explain why he considered the design and impact of the schemes was consistent with the policy requirements and objectives, notwithstanding Mr. Stewart's assessment, Mr. Alford chose in his examination and chief presentation to show only one image to represent the relationship between the schemes and the Shard, that of the view over London Bridge looking south. He presented none of the images that show the two buildings in close alignment or proximity. For example, the view from Southwark Street east of the railway bridge, Southwark Street, Stoney Street, or the War Memorial on Borough High Street, even though he agreed that these images are plainly relevant for you and the Secretary of State to consider. The impact in these viewpoints is stark. Quite clearly runs contrary to the objectives of the Southwark Plan in terms of the role and status of the Shard within the townscape. Why choose to avoid them when dealing with this point? No independent and impartial assessment or presentation in relation to this issue would do so. The only explanation would seem to be a desire to avoid acknowledging and dealing with the harmful impact and policy conflict that they reveal. So in conclusion, the schemes would conflict with the development plan policies you identify, as well as the good design requirements of the framework and the National Design Guide. Very significant weight should attach to this policy conflict and the harms that flow from it. Indeed, it's difficult to conceive of circumstances in which a tall building that fails to accord with these centrally important policies could be judged to be acceptable, let alone to accord with the development plan overall. Now, Madam, I then deal with servicing for the 2018 scheme, which I propose to take as read. And then a couple of pages further on, I deal with the daylighting issues, which again, if you're content, I propose to take as read. And then I will pick up the text again in relation to benefits at page 50 in paragraph 141. As we explained in opening, the principal differences between the parties in terms of the identification of public benefits flow from the LPA's heritage and design and townscape likely reasons for refusal. Beyond the modest heritage benefit of restoring the Georgian Terrace, the LPA does not accept that either scheme delivers heritage benefits. Further, on the basis of Miss Adams' evidence, the design of the schemes is far from exemplary and is instead harmful, and there is consequently no public benefit associated with the quality of the design of either scheme. The differences between the parties with regard to the weight to be attached to public benefits and the calibration scales of each of the respective witnesses is set out to the notes submitted to the inquiry yesterday. We don't address each and every difference in opinion, but instead we focus on the main points. First of all, economic and employment floor space. One of the key differences between the parties is the significance of the fact that the LPA can comfortably achieve the Southwark Plan's strategic targets for the delivery of employment floor space and economic growth over the plan period without the additional windfall floor space that will be contributed by one or other of the appeal schemes. It's the LPA's case that this necessarily bears on the weight to be attached to this benefit. Mr Glasgow explained that in generating figures for how growth should be distributed within the borough in the Southwark Plan, the LPA has had regard to a variety of different sensitivities and considerations. In that context, the addition of substantially increased levels of employment floor space in any one location, particularly within a relatively mature area such as London Bridge, cannot simply be assumed to represent an unalloyed benefit. In short, if one keeps introducing further substantial levels of growth beyond what has been planned for in the Southwark Plan, having regard to opportunities and constraints, the risk is that harms are introduced that go beyond those reflected in the balance struck in the development plan. That's the context in which to consider the significance of the additional benefit generated by surpassing the levels of growth identified in the plan, alongside consideration of the impact that this might have on the delivery of sustainable development more generally. The London Plan expects the special features that Londoners value about a place, such as historic elements, should be used positively to guide and stimulate growth. As Mr Goddard accepted, in some cases that will mean guiding particular forms of development away from valued heritage assets. That may help to stimulate growth in less sensitive locations. This approach is consistent with the concept of good growth, rather than simply growth at any cost, that underpins the development plan as a whole. In circumstances in which the LPA has a clear pipeline of delivery of employment floor space in the London Bridge area, the weight that should attach to the benefit of further floor space is fairly characterised as moderate. Mr Goddard treated the identity of the appellant as a factor that justified the application of additional weight to the provision of office floor space, given the appellant's track record and ability and commitment to deliver the scheme, if permitted, within a short timescale. That approach is misconceived in circumstances where it's common ground between the parties that there is no proposal to make a grant of permission for either scheme personal to the appellant. There's nothing to prevent the appellant from selling the site to another developer with the grant of planning permission. There's nothing to stop the appellant from changing their corporate approach for commercial reasons at some future date, and, for example, not delivering the scheme themselves or coming back with a different scheme. If planning permission is granted, a material weight is accorded to the appellant's track record. There's no comeback if the appellant does not in the event deliver the scheme. Aside from the standard condition regarding the implementation period for a permission, there's nothing proposed to secure the timing of delivery. The appellant has not explained their intended delivery timescales for the scheme should permission be granted. There is another significant practical hurdle to be overcome before the development could be implemented, namely the need to enter into a development agreement with TfL under LUL for the delivery of the station works. The matters to be covered by the development agreement are set out in Schedule 5, Clause 1.2, and include a range of technical design, protective, commercial, consenting and licensing matters, which will necessarily take some time to complete. Whilst the parties are obliged to use reasonable endeavours to reach agreement, the history of negotiations with LUL just to establish agreement to the principle of a new access point suggests that agreement on all points of detail for the design and implementation of the station works will not be straightforward. In the light of these factors, the identity of the appellant is irrelevant to the weight to be attached to this benefit. Then jobs. The appellant has also overvalued the scale of the benefit arising from the provision of new jobs associated with the schemes. It's agreed that in judging the weight to be attributed to this benefit, it is relevant to compare the number of jobs provided by the schemes with the jobs delivered by other comparable office-led development in Southwark, as well as a London-wide comparison. So far as the local Southwark context is concerned, no challenge was made to Mr Glasgow's evidence that the number of jobs delivered by the schemes is commensurate with similar developments in the areas such as Beckett House and Vinegar Yard. Further, no challenge was made to his assessment that if the delivery of one of the schemes was combined with Vinegar Yard and Beckett House, together they would make up approximately the 10,000 jobs total required in the entire Bankside Borough and London Bridge opportunity area for the whole plan period. The substantial contribution made by those schemes towards the target in this part of the opportunity area is relevant to the weight that should be attributed to the windfall benefit provided by this scheme. On a London-wide scale, it's agreed the delivery of the additional jobs associated with the scheme is not significant. That's reflected in the ES scoping report for the 2018 scheme, which treats the provision of new jobs as an insignificant socio-economic issue and states that while this job creation is large in number, will contribute towards job creation targets and is clearly an economic benefit, these jobs are unlikely to be materially significant in the context of the wider London area. That conclusion is significant. In cross-examination, Mr. Goddard's attention was drawn to his previous acceptance that the production of and content of environmental statements are subject to the EIA regs and guidance and undertaken by appropriately qualified experts. This is agreed to be important because of the role the ES is intended to play in informing decision-making on substantial proposals and facilitating public involvement in decision-making. Mr. Goddard agreed that nothing relevant has changed since he accepted those points of principle, and that they applied just as well to a considered and reasoned decision to scope out the potential positive effect pursuant to the scoping process set by the EIA regulations. There was a subsequent attempt in re-examination to distance the appellant's case from what was said on its behalf during the scoping process by emphasising that this was considering significance on a London-wide basis. That attempt was misguided for two reasons. First, as with all environmental topics, it's a matter of judgment for the appropriately qualified experts to determine the most appropriate basis to judge significance, having regard to the proposed development and the nature of the effect under consideration. In this case, the relevant experts have judged that the most appropriate basis for assessing significance is to look at what will be delivered in the London context. It's not an arbitrary choice, but one informed by expert judgment on the facts of the particular case. Any ex post facto attempt to disown that choice to suit the appellant's arguments in an inquiry should be given short shrift. Secondly, in this case, the adverse townscape and heritage impacts of the proposed development will be felt far beyond the local context. They also adversely affect heritage assets which are significant at a London, national, and in the case of the World Heritage Site, international level. If the scale of employment benefits are such as to be material only at a local level, that is itself a strong indicator they are unlikely to attract the sort of weight needed to outweigh those adverse impacts in the balance. Next, affordable workspace. The LPA has acknowledged the provision of 10% affordable workspace to be a benefit to which significant weight should attach. Whilst the level provided is the minimum needed to comply with policy, the provision of such floor space is a strategic priority. Notable, Mr. Goddard only ascribes moderate weight to this benefit, and the contrast with Mr. Glasgow's more generous position makes it hard to understand the appellant's accusation that the LPA is talking down the benefits, or that the main reason the weight attached to benefits is not agreed is because Mr. Glasgow appears to attach reduced weight to benefits which do not extend beyond the policy requirement. Neither accusation is accurate or fair. Mr. Glasgow has given a clear, considered and eminently reasonable explanation for the weight he has accorded to each benefit in this case. In evidence, the appellant has sought to rely on the potential for King's College London to take space in the affordable elements of the scheme, either alone or as a joint venture with the Guy's and St Thomas Trust, as being relevant to the weight that attaches to the affordable workspace. That reliance was misplaced, as became apparent during yesterday's Section 106 session. On behalf of the appellant, it was explained that no reliance was in fact placed on any particular occupier for the purpose of the planning balance, and that is sensible. There can be no guarantee that either will take space in the development, and indeed the space has not been specifically designed for their purposes. It's possible that KCL and or GST may take space in the building, but it's equally possible they do not. No weight can therefore be attached to that factor in the planning balance. Then environmental and social benefits. The new underground station access is acknowledged to be a public benefit, but the parties differ substantially regarding the appropriate weight that attaches to it. There's no evidence that LUL has ever identified a need for change to or enhancement of the existing access on the east side of Borough High Street, nor is there evidence that LUL considers the existing access as not functioning satisfactorily. Absent the proposed redevelopment of the appeal site, all indications are the existing access would not be likely to change or need to change anytime soon. TfL is consulting on separate proposals to increase the space available to pedestrians on this side of Borough High Street and into St Thomas Street, which would serve to reduce congestion on the pavements, including the pavement outside the station access. The view of TfL is that the new access is required to meet an acceptable pedestrian comfort level, and so it is necessary mitigation to address what would otherwise be a potential obstacle to the grant of planning permission, rather than representing a pure enhancement. Further, beyond providing a convenient access into the development for those employed in the retail and workspace, the extent to which the new access will represent a significant benefit to other underground users is limited. This is due to the following factors. The existing entrance and exit on the east side of Borough High Street is a secondary access, used by about 12% of those using the station in comparison to the far busier access points on St Thomas Street and Duke Street Hill. The fact that there is already an entrance and exit for those who wish to come out of the station and go one way or another along the east side of Borough High Street means that for those seeking to go north and south on Borough High Street, the new access is simply a further means of entering and exiting the same existing secondary point of access to the station. As the space syntax studies show, most of the existing pedestrian traffic exiting the station on the east side of Borough High Street heads north, south or west, and only a limited proportion presently heads east along St Thomas Street or into Kingshead Yard. So a relatively small proportion of total users of the station use the existing Borough High Street east access point, and of that relatively small proportion, only approximately 1 in 5 current users of this access would benefit from a new access point that allows for a more direct route east. Taken together, these contextual factors mean this benefit is not properly characterised as exceptional, and Mr Glasgow is right to accord moderate weight to it. At a very late stage, and clearly conscious of the unhelpful implications of the figures in Mr Alford's proof of evidence, the appellant introduced a new analysis, seeking to show that 70% of those using the new access to the station would be travelling to somewhere other than the development. Even when committed to writing, the basis of these figures was somewhat opaque. As Mr Glassow's subsequent note explains, clarification of the underlying figures with the assistance of AHMM suggests that the percentage figure relies on a number of unstated and in places questionable assumptions. In particular, it's assumed that a large number of those who currently exit onto Borough High Street to travel south along that street will henceforth eschew that option and then would instead exit to the east before doubling back along King's Yard to Borough High Street and continuing their journey as before. Even assuming that's likely, and it seems counterintuitive, the actual level of benefit, if any, to those commuters compared to the existing position must be very limited indeed. In relation to the weight to be attached to the public realm, the shortcomings of the public realm and ground floor level we've identified above in terms of its quality, size and function justifies the application of limited weight to this benefit. Further, whereas the appellant sought to present the elevated public gardens that will be delivered by the schemes as an out of the ordinary public realm benefit, the provision of elevated public space is expected by both parts of the plan for tall building proposals, and there is therefore nothing unusual or exceptional about its provision in these schemes. The appellant attaches substantial weight to the delivery of zero carbon measures secured by condition. The LPA's view, as explained by Mr Glasgow, is that very limited and limited weight should attach to these sustainability measures. When judging the overall sustainability credentials of the appeal proposals, it's relevant to consider the wider context. The demolition of the existing building, which appears to be fully occupied, and its replacement with a wholly new building is an inherently resource-intensive approach. There is very limited evidence of any serious consideration being given to alternative approaches which are less carbon-intensive and more sympathetic to the site's context. Mr Alford was unable to point to any evidence to demonstrate that it would be unviable to adapt to extend the existing building, other than his assertion that this was the position. Further, neither scheme can fairly be characterised as an exemplar in terms of delivering sustainability benefits. Rather than providing detailed information as to compliance with the range of sustainability measures up front, demonstrating these matters have been driving factors throughout the design process. Both schemes defer compliance in respect of a number of measures to conditions, with the 2018 scheme deferring a greater number of matters than the 21 scheme. So then the heritage balance. The LPA's evidence on the heritage balance is provided in Mr Glasgow's proof. The modest public benefits do not outweigh the significant harm to the assets we list there and the considerable number of other heritage assets. Then next, whether the proposals are in accordance with the development plan taken as a whole. It's common ground between the parties that relevant factors in considering whether the appeal proposals are in accordance with the development plan as a whole include the importance of the policies complied with or infringed, the extent of compliance or breach, and the overall thrust of the development plan policies. We've already referred to the strategy of the development plan to deliver good growth. The concept of good growth that is said to underpin the London plan is defined as growth that is socially and economically inclusive and environmentally sustainable. In accordance with paragraphs 8 and 9 of the framework, the development plan seeks to achieve sustainable development in precisely the manner that national policy requires, through the delivery of the interdependent economic, social, and environmental objectives, which are to be pursued in mutually supportive ways. Mr. Goddard accepted in cross-examination that the good growth concept is relevant to an understanding of the overall thrust of the development plan policies. High-quality design that is appropriate to its context and respect for and the conservation and enhancement of heritage assets are essential as component parts of delivering good growth and must be achieved alongside and in concert with the delivery of economic objectives. The development plan does not view these as objectives pulling in different directions. London's heritage is rightly viewed by the London Plan as of strategic importance to ensuring the city's success, and it is clear that this strategic role should not be sacrificed when seeking to achieve economic growth. Further, a design-led approach to development and understanding what is valued about a specific place is seen by the London Plan as being of strategic importance to the delivery of sustainable development and growth. These strategic objectives and the interrelationship between delivering economic benefits and a high-quality design that promotes and respects local distinctiveness and heritage permeate throughout the London Plan. The same interrelated objectives also underpin the Southwark Plan's approach, the spatial strategy for which is to continue with regeneration and preservation to create destinations, town centres and residential communities that preserve and enhance the history of places, particularly historical buildings and open spaces. In this context, Mr. Glasgow was right to take the view that where a proposal gives rise to significant harms in relation to heritage and design matters, the strategy for good growth is undermined even where economic benefits are delivered, and it's appropriate to conclude that there has not been compliance with the development plan as a whole. Mr. Goddard accepted in cross-examination that to deliver growth that is good, the growth must not just deliver economic benefits, but must also deliver a high-quality design that promotes and respects local distinctiveness and heritage. However, he also expressed the view that eroding the distinctiveness of an area and failing to preserve the historic character of London's unique places through development would be consistent with the broad thrust of the development plan. That position is untenable. His view was that the overall thrust of the development plan strategy was to drive business growth and change. That is not what either part of the development plan actually says. Furthermore, not only was Mr. Goddard's assertion fundamentally inconsistent with his concession regarding the remit of the good growth strategy and the plain wording of that strategy articulated throughout both parts of the plan, this misunderstanding of the overall thrust of the plan helps to explain his distinctly unbalanced view of the relative importance of protecting the historic environment and promoting economic growth, and the way in which those two objectives are expected to be pursued. The schemes conflict with development plan policies relating to tall buildings, design and architectural quality, the protection of World Heritage sites and other heritage assets, strategic views, public realm, and servicing. These policies are not only amongst the most important in the development plan, they are necessarily of central importance to any determination in this case. The schemes also conflict with the overall thrust of the development plan and its strategy of seeking to achieve good growth. The nature and extent of the conflict is substantial. As such, the proposal is in conflict with the development plan when considered as a whole. And finally, the overall planning balance. In accordance with section 38.6, the appeals must be determined in accordance with the development plan unless material considerations indicate otherwise. In this case, both schemes conflict with the plan as a whole. The plan is agreed to be up to date, and there is common ground that this will tend to increase the weight that attaches to policy conflict. In accordance with the statutory presumption in favour of the development plan, permission should not therefore be granted unless other material considerations indicate otherwise. The presumption in favour of refusal arising from the development plan is supported in this case by the strong statutory presumption in favour of refusal that arises because of the harm caused to designated heritage assets. None of the other material considerations in this case would justify the grant of permission. The most important other material consideration in this case is the harm that will be caused to interests of acknowledged importance and which has given rise to the policy conflicts. Very substantial weight should be given to that negative factor in the planning balance. There are benefits of the schemes, but the collective weight that they attract is relatively modest in comparison, and very far from capable of tipping the balance in favour of granting planning permission. And so in conclusion, for the reasons summarised above, the Section 78 appeals should be dismissed and planning permission refused for both schemes. And those are my submissions, unless I can assist otherwise. And you'll see we provided an appendix with definitions.
Thank you very much, and you bang on time as well. Impressive. Okay, all right. We'll have a break now, and then we'll hear Historic England's closing. I don't know if you're swapping seats or coming up to the witness table, or.
Yeah, I mean, we haven't discussed it. I don't mind. I'm quite relaxed. I'm happy to stay here, and if anyone wants to pass me a note, they can. Unless it's better for you if I'm closer.
It is a bit better, but I'm not.
There's also the camera. I don't know whether the camera.
Well, no, I think that would need to be set up as well. So
maybe we'll just swap seats.
Okay. All right. Thank you.
Thank you.
We'll reconvene at 12:30 and 11:30 then. Thank you. We've got Historic England's closing submissions when you're ready.
Thank you. And Madam, it's another long document, I'm afraid, but I'll take the same approach as my friend Mr. Philpott, and I'll sort of skip over bits as we go through. And just before I start, I've got a note on referencing at the top. Unfortunately, I've not provided the helpful kind of list of acronyms that the council did, but I've been through those, and I think essentially the acronyms I've used are the same as what they've used. So hopefully that should be clear. So by way of introduction, I observed in opening that HE does not routinely appear as a Rule 6 party at planning inquiries. The step is not taken lightly and is reserved for the most serious cases where HE considers the heritage impacts of a scheme would be particularly harmful. HE's advice on GPE's tall building proposals has remained utterly consistent from the pre-application response right up to today. I invite you to review the pre-application response letter dated 9th of July 2018, and you'll see that precisely the same concerns were raised about the effect of a tall building on this site, in terms of the heritage assets that would be harmed, the way the harm would arise, and how serious it would be. In line with HE's role as the government's expert advisor on the historic environment, these submissions focus on heritage matters. There are, of course, certain areas of overlap with other topics considered at the inquiry, in particular design and policy. HE has sought to engage with those issues only insofar as they are relevant to the assessment of heritage impacts. It will have been clear from the evidence that HE does not advance a case on the weight to be given to non-heritage related public benefits and has not attempted to strike the overall planning balance. This requires consideration of a range of matters outside HE's specialist area of expertise. That said, having heard and reflected on the evidence of all parties, HE remains convinced that the proposed buildings would be very damaging to some of London's most special historic places. Bearing in mind the weight that must be accorded to the harm, given its extent and the importance of the assets, weighty public benefits will necessarily need to be found in order to clearly and convincingly justify a grant of planning permission. As explained in opening and by Mr. Young in evidence, HE has sought to take a proportionate approach and is focused on the heritage assets which would either suffer the greatest harm or which are of the highest significance. Ultimately, all parties have adopted a similar focused approach in presenting their cases. Whilst you have evidence before you on a wide range of heritage assets that are potentially affected, your findings on the 5 key assets covered in HE's case appear likely to be determinative. I then set out the structure of the remaining submissions, and unfortunately I've managed to miss out what should be Roman numeral 6, which is the section on the listed terrace. So if you can bear that in mind, and all the numbering after that will obviously shift up on. So the first topic, it relates to matters of law and policy. And in terms of the decision-making framework, I'm not going to read out paragraphs 7 to 11. That is just summarising some of the relevant statutory provisions here. But I will pick up the point at paragraph 12 and emphasise 2 further points which flow from those provisions and which are relevant to points made later. And they are that first, section 66 gives equal treatment to both a listed building and its setting, and it therefore follows that harm to the setting of a listed building must be given considerable importance and weight, and engages the same presumption as harm to the building itself. Any approach to assessment which has the effect of relegating setting to a secondary or less important consideration would be inconsistent with section 66 and wrong in law. And secondly, section 69 makes clear that the character and appearance of a conservation area which is to be preserved or enhanced is that which embodies or reflects the special architectural or historic interest which justifies the designation. The Listed Buildings Act is plainly not intended to protect aspects of character which do not sustain or which detract from that special interest. It's common ground that when considering whether a building would preserve or enhance the character and appearance of the conservation area, the question is how it relates to the special interest of the conservation area, not how it fits with the character of the area in general or in a townscape sense. I don't then read out paragraphs 13 and 14, and I then turn to a section on significance and setting. The concept of significance within the framework is equivalent to the special interest for which listed buildings and conservation areas are designated. The framework further confirms that significance derives not only from a heritage asset's physical presence, but also from its setting, and that the cultural value described within the Statement of Outstanding Universal Value for a World Heritage Site forms part of its significance. With the exception of the Borough High Street Conservation Area and the listed buildings at 4-8 and 12-16 St Thomas Street. All of the heritage impacts arising in this case are setting impacts. Mr Stewart confirmed that in such cases, any assessment must consider the twin roles or elements referred to in the NPPF definition of setting, namely whether the development would make a positive, negative or neutral contribution to the significance of the heritage asset, and how the development would affect the ability to appreciate that significance. In cross-examination of Dr Barker-Mills and Mr Young, my learned friend Mr Katkowski questioned how the effect of development on the ability to appreciate a heritage asset, for example by drawing the eye away from it or introducing a visual distraction, could amount to harm. It was suggested that relevant heritage harm could only occur if there was an effect on the heritage interest of the asset itself. You will undoubtedly recall Dr Barker-Mill's vivid example of how he could distract attention and draw the eye away from your importance and authority by waving his arms around without actually making you any less important or authoritative. This moment of levity deftly illustrated a serious point about how development in the setting can undermine heritage value. The Listed Buildings Act extends protection to the setting of listed buildings because it recognises that what happens in the setting can affect the special interest of the building, even if there's no effect on the fabric. This is reflected in the framework, which invites consideration of how the setting of a heritage asset allows it to be experienced or appreciated, as well as what it contributes to the asset's significance. Historic places are not given statutory protection for their own sake. They are protected for their special interest and value to people. The framework captures this point, stating that the purpose of conserving heritage assets is so that they can be enjoyed for their contribution to the quality of life of existing and future generations. Similarly, significance is defined as the value of a heritage asset to this and future generations. Of course, it is harmful if a new development undermines or reduces people's ability to experience and appreciate what is of value about a historic place. The importance of considering how significance is experienced and appreciated is reflected in the PPG. This confirms that environmental factors such as noise, dust, smell and vibration, and our understanding of the historic relationship between places can affect the way an asset is experienced in its setting. Clearly, such factors relate to experience and appreciation, not the special architectural or historic interest of the designated heritage asset itself, and they are regarded as relevant by the government. I then give some references to further support for this point in other guidance. And finally, on this point, it can be noted that whilst the appellant's advocate suggested that effects on the ability to appreciate a heritage asset might not play into harm to its heritage interest, GP's own heritage expert concluded that the proposals would cause less than substantial harm to Guy's Hospital and Southwark Cathedral by compromising the ability to appreciate their significance from parts of their settings. I then move on to some points about the approach to the assessment of harm, and firstly, the Edith Summerskill House and Tulip decisions. The different approaches taken by inspectors and endorsed by the Secretary of State in those decisions was explored in some detail during the oral evidence. They were both cases involving development in the setting of heritage assets, and they revealed two different approaches to determining the degree of less than substantial harm caused by a proposed development. In Edith Summerskill House, the inspector sought to gauge the proportion or component of the significance of a listed church and a conservation area, which could be attributed to their settings and would therefore be affected, in order to decide the extent of harm caused by the proposed tall building. Because the overwhelming proportion of the church's significance was locked into its form and fabric, and impacts on significance would only occur from a few places in the churchyard or cemetery, the inspector found that the harm would be very much at the lower end of the scale, and a similar approach was taken to the conservation area. In the Tulip appeal, the Secretary of State endorsed the inspector's approach that when assessing harm, the key point is not whether some aspects would be left untouched, but the importance of what would be affected, that is, the setting, to its significance. The difference between these two approaches was perhaps best encapsulated by Dr. Barker-Mills, observing that the inspector in Edith Summerskill House appeared to be looking at the issue of harm quantitatively rather than qualitatively. None of the heritage witnesses discussed these competing approaches or sought to explain how they determined the degree of less than substantial harm caused in their briefs. However, it can be seen that both Mr. Young and Dr. Barker-Mills both took a qualitative approach which most closely aligns with the Tulip decision. They did not attempt to identify the proportion of significance affected in any given case. Instead, they sought to identify the aspects of significance which were particularly relevant, given the nature of development proposed, and then considered the extent to which those aspects would be affected. This is most easily illustrated by the assessments of the Tower of London World Heritage Site, where both witnesses identified the attributes which were relevant and then considered how far the proposals would affect those attributes. Mr. Stewart's approach was harder to discern. In evidence in chief, he said that he agreed with paragraph 1250 of Edith Summerskill House, but under cross-examination, he confirmed that he'd followed the approach set out in the Tulip and did not seek to justify a different approach. When I explored this in cross-examination, Mr. Stewart agreed that he'd considered the proportion of significance derived from the fabric and setting of Guy's Hospital, respectively, and had taken account of how much of Southwark Cathedral's setting was unaffected or left untouched. So his assessment does seem to be more aligned with Edith Summerskill House than the Tulip. HE's position is that of these two approaches, that taken in the Tulip appeal is clearly to be preferred. It's a simpler, straightforward approach which looks at what is being affected and why it's important. It avoids a mechanical or mathematical exercise, which might otherwise be felt necessary in order to determine what proportion of significance would be affected. The Tulip decision is recent and concerned the same World Heritage Site, which is at issue in this case. It would seem to be appropriate to take a consistent approach to assessing harm in this case. HE considers that Edith Summerskill House does not sit very comfortably with the equal treatment of listed buildings and their settings under Section 66. The inspector's view was that unless the asset concerned derives a major proportion of its significance from its setting, then it's very difficult to see how an impact on its setting can advance a long way along the scale towards substantial harm. Since it's hard to imagine any listed building which would derive a major proportion of its significance from its setting, bearing in mind the designation is for the special interest of the building itself, this approach appears to make findings of high levels of harm less likely in setting cases. On the face of it, this would make such harm easier to justify. The point is illustrated by Mr. Stewart's evidence. He believed that paragraph 1250 of Edith Summerskill House was consistent with the big difference he saw between direct effects on the fabric of a listed building and indirect effects from development in the setting. Yet there is no difference in how these effects are treated under Section 66. For similar reasons, the Edith Summerskill House decision also sits uneasily with the PPG, which states that substantial harm may arise from works to the asset or from development in its setting, and that even minor works have the potential to cause substantial harm depending on the nature of their impact on the asset and its setting. The government clearly recognises that development in the setting of a heritage asset can cause a high level of harm, whereas this would seem unlikely adopting the approach in Edith Summerskill House. Under cross-examination, both Dr. Barker-Mills and Mr. Young gave examples of development in the setting of listed buildings which, while not affecting any of the significance locked into their fabric, would clearly produce a high level of harm. Dr. Barker-Mills referred to the building of a small house in front of the Royal Crescent in Bath, while Mr. Young spoke about building a wall around the entirety of St. Paul's Cathedral. Clearly, these are extreme hypothetical examples, but they show how focusing on the proportion of significance, either affected or left untouched, might produce outcomes which defy common sense. The legal position is clear. There's nothing in the Act or in the framework or anywhere else which mandates a single approach to determining the extent of harm. This is left to the judgment and expertise of planning inspectors, or in this case, the Secretary of State. The approach you take to determining the degree of less than substantial harm to any heritage asset in this case is a matter for you, provided it's a reasonable one. If a choice has to be made between the two approaches just discussed, then HE invites you to adopt the Tulip approach. However, there may be other approaches entirely which would be equally acceptable. I've then got submissions about substantial harm and the boundary between substantial and less than substantial harm, and on the range of less than substantial harm. So I'm not going to read those out. And then I'm also going to take as read the section on the weight to be given to heritage benefits, and I'll pick up at section 3, which is a discussion of some other overarching issues that have arisen through the evidence. And the first is the extent to which heritage has informed the design of the proposals. The design and access statement should provide an account of the design process, including an explanation of how the proposed development is a suitable response to the site and the surrounding area. Given the location of the appeal site in a central position within the conservation area, it's reasonable to expect that the DAS would explain how the proposed tall buildings attempt to respond to the character and appearance of the area. It's fair to say that the DAS contains a good amount of detail about the heritage assets within the site itself, and there is some discussion of the history of St Thomas Street and King's Head Yard and the setting of the King's Head pub. On the other hand, analysis of the character and appearance of the Borough High Street conservation area is seriously lacking. The only explanation of how the schemes respond to the special architectural and historic character of the area is in discussion of design references and palette. Consideration of how the form and scale of the building and the layout of spaces relates to the conservation area context is entirely lacking, although tellingly the 2018 DAS notes that the building should be set back as far as possible from the High Street. Unsurprisingly, given the responses of consultees to the 2018 scheme, the 2021 DAS shows a greater level of awareness of the negative effects of a tall building on heritage assets. For example, there's a reference to heritage settings as constraints in height definition, leading to what is described inaccurately as a mid-rise tall building proposal, and an acknowledgement that attempts should be made to provide greater distance away from the rear of the listed Guy's Hospital. Notwithstanding this, analysis of the conservation area is no more advanced in the 2021 DAS compared to the 2018 version, and although the conservation area appraisal contains clear guidelines for development, there's been no analysis in either DAS or elsewhere of how the schemes perform against them. Further doubt arises as to the relevance of heritage considerations to the overall design when one considers the following. Firstly, within the first 6 to 9 months of becoming involved with the site, AHMM had decided that a new building should be provided that should become another addition as part of the important cluster. It's clear from Mr Alford's evidence as a whole that the design has sought to respond and relate to the tall buildings at London Bridge Station, leading him to describe the 2018 scheme as working with the composition of the tall buildings and bringing this part of the cluster to a satisfactory condition. There was a conscious choice to develop a building with a form and appearance which responds to the collection of existing tall buildings rather than the conservation area. Secondly, this design intention is clearly reflected in the Metabolist Tower, which was one of the earliest iterations of tall building design and which is represented by a model in the inquiry room. One down there, which is probably quite hard for you to see, madam, from where you are, but it's there. This building is roughly 3/4 the height of the Shard, and it's a clear visual demonstration of GP's intent to respond to the existing tall buildings and their failure to pay any serious attention to the constraints imposed by the conservation area. And I'm just going to interpose there, madam, to say, in terms of the model, be conscious that we did a walk round and had a look at that quite early on in this inquiry. And since then, you've been sitting here and looking at the model from the position where you are. And what we would like to invite you to do is obviously revisit the model, look at it again, but particularly from where we've been sitting down our end of the table for the last 3.5 weeks, where you're actually looking there kind of across the conservation area and kind of getting a different perspective there. And that, I think, demonstrates the differences in scale and also the differences between the scale and form of development inside the conservation area boundary and outside it. So we invite you to do that. And then the third point on this is that Mr Stewart confirmed that all design iterations, which were tested against the 7 key benchmark views agreed with Southwark in 2015, produced the same adverse effects. These effects flowed from the principle of a tall building in this location rather than any matters of detailed design. It's therefore unsurprising that the 2018 and 2021 TVI BHAs find the same level of adverse effect for both appeal schemes. Despite this, and despite Mr Alford agreeing that a robust and reliable analysis of heritage impact was very important to the design process, neither Mr Alford nor Mr Stewart suggested that GPE should consider a different form of development. Mr Alford's evidence was that he did not think the less than substantial harm would ever be addressed, which is plainly the case if a tall building is the only form of development that will be contemplated. The evidence has demonstrated that the building's designs have not been adequately informed by the heritage context, in particular the character and appearance of the conservation area, which forms the immediate context of the appeal site. GPE are clearly an experienced developer and have had heritage advice throughout the proposals, so it's unlikely they've been unaware of the inherent tension between the schemes and their historic context. Rather, they've treated this as something that will need to be accepted if redevelopment is to occur. Hence the line of questioning of Dr. Barker-Mills, which suggested, in the context of the area identified in Policy P17, that some harm to heritage is inevitable and effectively priced in to any tall building development. GPE have been unwilling to consider the possibility that despite the inclusion of the site within a very broad area where Southwark expects tall buildings, it may not actually be suitable for such development. I then move on to the issue of design quality. GPE have advanced the proposition that good quality design could, in principle, reduce the level of harm caused by a tall building. Mr. Young was prepared to accept this possibility, but believed that it would depend on the type of building being considered and the nature of the context. Dr. Barker-Mills was also prepared to agree to the idea in principle, although he felt it would be hard in practice given that exemplary design is a policy requirement. Ironically, Mr. Stewart did not subscribe to the idea of high quality design reducing harm, although he was clear that poor design could exacerbate it. His conclusions on heritage harm reflected the harm caused by a high quality scheme, and unsatisfactory design would be more harmful in his view. HE's position, as expressed through GPA 3, is consistent with Mr. Young's oral evidence. For some developments affecting setting, the design of a development may not be capable of sufficient adjustment to avoid or significantly reduce the harm. For example, where impacts are caused by fundamental issues such as the proximity, location, scale, prominence, or noisiness of a development. In other cases, good design may reduce or remove the harm or provide enhancement. The heritage harm identified in this case results from the principle of introducing a tall building in this location. The form and scale of this type of development produces specific types of effect, dominating the existing street scene, dominating the historic foreground, which will not change whatever variation on design is chosen, as confirmed by the fact that none of the iterations tested, and that probably should be by Peter Stewart, produce any different results. In any event, the designs of these schemes are now fixed and are presented for determination. It may be the case that a building with poorer design quality would produce even greater harm, but that doesn't take GPE anywhere. A related point which was explored in the evidence was the extent to which a building could properly be considered to represent good design if it did not appropriately respond to its context, historical or otherwise. Ms. Adams expressed the view that it was not possible to isolate the concept of architectural quality from its context and setting, and that while it might be perfectly possible to have enjoyable compositional concepts considered in isolation, when those were put into context and tested, any good qualities were undermined. Mr. Stewart took a different approach. His assessment involved first reaching a conclusion on the design quality of each building in its own right. That conclusion was then carried forward into and informed the assessment of heritage impact. Mr. Stewart felt that it was proper to consider the inherent quality of design separately from the question of whether the buildings would represent appropriate development in their context. Mr. Stewart's approach is not consistent with the National Design Guide, which confirms that well-designed places are responsive to local history, culture and heritage, and that well-designed development is demonstrably based on an understanding of patterns of built form and architecture prevalent in the area to inform the layout, form and scale of development. The NDG provides a series of tests for assessing whether a place is well designed or not. If they are not met, then it can be concluded that it is not well designed. This document is part of the PPG and serves as recent confirmation that so far as the government is concerned, the relationship between a proposed building and its heritage context is fundamental to the question of whether it can be considered good design. The same point is echoed in the approach of the inspector in the Chiswick Curve decision. The failure of these schemes to respond appropriately to their historic context prevents them from being regarded as well designed. Regardless of the perceived architectural quality of the buildings in their own right, the evidence has demonstrated that any tall building proposal will cause an equivalent level of harm to heritage, including to a Grade 1 and 2-star listed building. In the recently published second idea of HEAN 4, HE advises that there will be locations where the existing qualities of place are so distinctive and the level of significance of heritage assets so great that tall buildings will be too harmful, regardless of the perceived quality of the proposal's design and architecture. The appeal site is undoubtedly a location which falls squarely within this guidance. The existing qualities of the conservation area are highly distinctive, and the proposals would affect heritage assets of the highest significance. A tall building on this site will be too harmful, regardless of design. That was essentially Mr. Young's conclusion. The appeal site is simply not an appropriate location for a tall building. I turn to the treatment of existing buildings. Both Mr. Alford and Mr. Stewart relied heavily on the existence of tall buildings at and near London Bridge Station to justify the adverse visual and heritage effects they accept would occur. Mr. Alford considered that juxtapositions between tall buildings and low-level historic buildings were part of the character of the area and represented the layering of history. He said that the existence of tall buildings in and against the conservation area was clearly established and represented a successful model for the current history being laid down. Mr. Stewart variously described the proposed tall buildings as not bringing about any effects of a kind not already present in the conservation area and as consistent with the established character of the area. Similar themes can be detected in his analysis of effects on listed buildings, in particular Guy's Hospital and Southwark Cathedral. There are two fundamental problems with this evidence considered from a heritage perspective. First, as explained earlier, the character and appearance which Section 72 seeks to preserve and enhance is that which relates to the special architectural or historic interests of the conservation area and which underpins its designation. Mr. Stewart accepted that this was the case. Whatever the position in terms of townscape, which is outside HE's remit, it's obvious that the existing tall buildings near London Bridge Station are not part of the special architectural and historic interest of the conservation area, as summarised in the CAA. Whilst the CAA dates from 2006 and thus predates the modern development around London Bridge, earlier incarnations of tall buildings at London Bridge Station already existed at the time it was published. With the exception of Shard Place, the tall buildings and resulting juxtapositions relied on by Mr. Stewart and Mr. Alford, past and present, have been outside the conservation area boundary. The character and appearance of the conservation area itself has remained unaffected, and the consistent range of building heights and scales within its boundary remains. Nothing has materially changed in this respect since 2006, and I'll return to Shard Place later. Mr. Stewart repeatedly referred to the existing tall buildings and juxtapositions as being an important part of the character of the area. His failure to appreciate the distinction between character in a general sense and the character which is relevant under Section 72 is a glaring error in his assessment. It leads him to suggest that the proposed schemes are essentially in keeping with the character of this part of the conservation area, when in fact they would be fundamentally at odds with it. This inevitably undermines his conclusions. Second, Mr. Stewart confirmed that he had assumed that existing tall buildings have a positive effect on the character and appearance of the conservation area when undertaking his assessment. He did not undertake any systematic appraisal of those buildings to explore what about them could be regarded as beneficial. The same approach can be detected in his treatment of tall buildings in the setting of other heritage assets, including the Tower of London. Essentially, the existing tall buildings have been treated as part of the baseline, and there's been no attempt to consider whether they have a positive, negative, or neutral effect on the significance of any of the assets. They are just there. This is all the more puzzling, bearing in mind that Mr. Stewart has considered whether the existing buildings on the appeal site can contribute positively, negatively, or neutrally to the character and appearance of the conservation area. There's been no attempt to explain the difference of approach between existing buildings on site and existing buildings in the surrounding area. It can't be justified. My learned friend Mr. Philpott took Mr. Stewart through advice and guidance, all of which explain why it's important to assess whether existing development has caused harm. HEAN 4 reinforces this point in the specific context of tall buildings, stating that the issue of cumulative impact needs to be considered to ensure that, among other things, where harm already exists, it is not compounded. In other words, existing harmful development should not be used to justify further harm. Unfortunately, that's precisely what has happened in this case. Mr. Stewart confirmed that Guy's Hospital Tower has had a marginal effect on the ability to appreciate the significance of the Grade 2 star listed building. His attempts to avoid conceding the same point in respect of the listed terrace lacked credibility. Clearly, Guy's Tower has produced harmful effects to a range of designated heritage assets in its vicinity. Similarly, although Mr. Stewart considers the Shard to be of high architectural quality, he conceded that it has harmed the significance of Southwark Cathedral. These are two examples of how the existing tall buildings have compromised the significance of heritage assets in the conservation area and therefore harmed the conservation area itself. Mr. Stewart suggested that the appeal schemes would not harm the conservation area because the contrast in scale is comparable with that which results from the presence of the Shard, Shard Place and the Guy's Hospital Tower. In respect of Guy's Hospital, he stated that the effects would be comparable with the effects from the construction of the Shard and Shard Place and a continuation of the current state of affairs. If the existing buildings are in fact harmful, then the introduction of comparable effects is plainly adding further cumulative harm. Mr. Stewart acknowledged that he had not considered the issue of cumulative harm. This represents a major error in his approach. It's an error which Mr. Young and Dr. Barker-Mills have not made. Mr. Young has been clear that his view, and the view of HE corporately, is that the existing tall buildings around London Bridge Station have harmed the conservation area, Guy's Hospital, Southwark Cathedral, the Tower of London World Heritage Site and St Paul's Cathedral. He's properly taken that into account in his assessment of the effect of the proposals, concluding that the proposed schemes would produce cumulative impacts and exacerbate harm which has already occurred. Madam, I've then got some submissions specifically about Shard Place, which I won't read out, but you've got them there for your note. So I move to the next section, which is titled Judgments about the Quality of the Conservation Area and the Setting of Other Heritage Assets. A theme which came through repeatedly in Mr. Stewart's written and oral evidence was his focus on a notion of quality or attractiveness as a relevant consideration when assessing heritage significance and therefore impact. The idea being that less attractive conservation areas or settings, or those otherwise considered to be of lower quality, are less sensitive to the introduction of new development. This revealed itself in a number of different ways. First, the methodology of the Built Heritage Assessment identifies that the assessment of sensitivity may be moderated to take into account a judgment about the quality in the round. In cross-examination, Mr. Stewart confirmed that in performing the moderating exercise, he had taken into account of factors not relevant to the significance of the heritage asset or the ability to appreciate that significance. That cannot be regarded as a legitimate approach. Second, along similar lines, when discussing Southwark Cathedral, Mr. Stewart referred to the fact that it was not within a historic setting and was not a place where one could film a historic drama. This echoed a comment made in the heritage statement about the conservation area, which was that there's almost nowhere in the conservation area that passes what has been termed the Dickens test. That is, there are no areas that could be used to film a historic drama with a shot or sequence of shots that extend beyond a building or two. This Dickens test has no basis whatsoever in any law, policy or guidance. The idea that less historically intact places are less sensitive to new development is problematic in light of guidance on cumulative harm, as it can potentially create a situation where the more harm that occurs, the more further harm can be justified, and so on, until there's little of heritage value remaining. Third, during his oral evidence, Mr. Stewart sought to contrast the Borough High Street Conservation Area with Bloomsbury, which he regarded as more coherent in that a person could walk round a Georgian world. In his view, the Borough High Street Conservation Area is not an area of such coherence that something introducing significant change may disrupt it. This example was then taken up by Mr. Goddard, who compared the Borough High Street Conservation Area with Bloomsbury and other cherished conservation areas in London that are sacrosanct. This apparent ranking or grading of conservation areas has no basis in statute or policy and is not the result of any systematic analysis. It appears to be based on a subjective view about what matters, in this case, coherent design. This downgrading of conservation areas which do not strongly display Mr. Stewart's concept of coherency risks relegating other important aspects of character and appearance as somehow less valuable or sensitive. An example of how this has actually happened can be seen in the approach taken to King's Head Yard and other historic yards off Borough High Street. Mr. Alford in particular spoke of these yards in highly disparaging terms, describing King's Head Yard variously as an unwelcome backwater, an unsightly alley, a road to nowhere and a very, very difficult place to be, leading him to argue that the appeal schemes would relieve the misery of the yards. Mr. Stewart was slightly more measured, but still described King's Head Yard as not very nice and having a gritty quality. Yet these yards are highly significant remnants of a medieval street pattern which is unique in London. Perhaps unsurprisingly, given their shared background and experience as architects, both Mr. Alford and Mr. Stewart appear to place much greater weight on perceived visual quality and architectural design than other factors which may be relevant to the special interest of a heritage asset or the contribution made by its setting. The importance of these other factors is underestimated as a result. Fourth, on several occasions, Mr. Stewart took account of whether a particular view was one which a visitor would want to photograph. Again, this novel test or tool for assessing heritage effects seems to be one of Mr. Stewart's own confection. It suggests a confusion between pictorial quality or the attractiveness of a composition on one hand and the way the view relates to the special interest of a heritage asset on the other. The ability to see a nicely composed view is not the same thing as the ability to understand an aspect of heritage significance or appreciate that significance. Mr. Stewart's preoccupation with views and visual effects permeates his heritage assessment more generally. In cross-examination, he confirmed that where adverse visual effects were found in the TVIA, those were to be read across to the adverse effects identified within the BHA. The assessment of heritage impact starts and ends with the assessment of visual effects. Again, the risk is that other aspects of significance which are affected may be missed or given insufficient attention in the assessment. The further danger of basing the heritage assessment so heavily on the analysis of views is that the assessment will then miss out any adverse effects which have not been expressly identified through the views analysis. An example of where this had occurred was the view from the north of Southwark Cathedral, where for both schemes Mr. Stewart had assessed the effects as neutral in the TVIA, but accepted in cross-examination that there was in fact harm to significance, leading him to concede that paragraph 5.63 of his brief was incorrect. Another obvious example of heritage harm not picked up in the visual assessment was on St Thomas Street, where the assessed visual effect went from adverse from London Bridge Street to beneficial opposite Guy's Hospital within the width of Guy's forecourt. PS did not accept that the latter view was harmful in heritage terms, but his attempts to justify that conclusion were not credible. Madam, I'm not going to read out the next section on the treatment of benefits in reaching conclusions on harm. So I will turn to the next main section, which is where I just draw together some conclusions on law and policy and other overarching issues. The legal and policy context establishes the following as a correct approach to identifying and assessing the impacts of new development on heritage assets. First, identify the heritage assets potentially affected. Second, gain a proper understanding of the significance of the heritage assets potentially affected using available sources of information such as conservation area appraisals and other studies, as well as list descriptions and professional assessment. For conservation areas, this means having a clear understanding of the special architectural and historic interest of the area, the character and appearance of which is sought to be protected by the designation. Third, within the consideration of significance, consider the setting of the heritage asset and how it contributes to significance or how it allows that significance to be appreciated, and also consider any issues of cumulative harm arising from the presence of development which is detracting from significance or the ability to appreciate it. This should have been identified through consideration of existing significance and setting. Fourth, assess how the proposed development will affect the significance of the heritage asset, whether that is an effect on the fabric or on the relationship between the setting and the significance of the building. Whatever approach is adopted, it must not undermine the equivalent statutory protection given to listed buildings and their settings. Fifth, harm needs to be identified as either substantial or less than substantial, and the extent of harm within those categories should be clearly articulated. Identifying where the harm sits within a range or spectrum is one obvious way of doing this. Sixth, any harm to a designated heritage asset must be given considerable importance and weight, and creates a strong presumption against granting planning permission. The weight given to harm will increase depending on the importance of the asset and the extent of harm. Seventh, heritage benefits should be given great weight. Again, the precise amount of weight depends on the importance of the asset being enhanced and the extent of the benefit. And then finally, in a case of less than substantial harm, harm should be weighed against the public benefits of the proposal to determine whether it's been clearly and convincingly justified. This stage goes beyond consideration of purely heritage issues. I've explained how Mr. Stewart's assessment of heritage effects is undermined by several serious errors. These errors affect most stages of the assessment. And the existence of these errors may be explained in part by the fact that Mr. Stewart's background and qualifications are in architecture, whereas Mr. Young and Dr. Barker-Mills have a solid background in heritage. A further explanation may be found in the fact that Mr. Stewart, unlike Mr. Young or Dr. Barker-Mills, has been responsible for combining townscape and visual impact and heritage assessments within single documents. It's perhaps unsurprising that some concepts and approaches have become confused as a result. The series of errors I've identified means that Mr. Stewart's conclusions on heritage effects must be regarded as fatally flawed. The assessment has not been robust and cannot be relied on to inform the determination of these appeals. Mr. Young's evidence is clearly to be preferred. It's notable that although Mr. Young and Dr. Barker-Mills have undertaken separate assessments and presented them differently, there is good agreement between their findings on the 5 key assets HE has chosen to focus on in its evidence. Mr. Young was challenged in cross-examination as to his opinion on various points in principle, but criticism of his assessment of heritage impacts was limited to inconsequential matters such as his use of the word serious in describing harm and whether the appeal site could properly be regarded as being at the heart of the conservation area. Cross-examination did not expose any major flaws in his assessment. It was clear from Mr. Young's evidence that he has a deep understanding of the conservation area and the highly graded heritage assets within it, resulting from his involvement in Southwark casework for nearly a decade. That has included a lot of work relating to tall building proposals in the north of the borough. Mr. Young described some of the casework he's been involved with, including schemes which have led to real enhancements in the character and appearance of the conservation area. His long experience of working with heritage in Southwark is unmatched by either of the other heritage witnesses. It means that he has a really thorough understanding of the conservation area and heritage assets within it and what gives them their special interest and value. This makes his assessment reliable and credible, and his conclusions should be accepted. Move on to the assets, and firstly Borough High Street Conservation Area. In terms of its significance, it's long been recognised as an area of special architectural and historic interest. It was designated in 1968, just 1 year after the Civic Amenities Act 1967 first introduced the designation. Both Mr. Young and Dr. Barker-Mills emphasised the extraordinary time depth of the area. By way of example, Mr. Young noted the recent discovery of an incredible and largely intact Roman mosaic at the landmark court site on Southwark Street. In terms of urban grain, this long history of occupation has resulted in an area with a very rich history, with each period of history building on the one before and leaving its mark. This has led to a conservation area with quite distinct character areas, representing different stages of its development. The High Street is one of the oldest roads in London and still forms the spine of the area and is its most powerful influence. The distinctive medieval grain of the High Street and land adjacent still survives and is clearly legible. Mr. Young explained that there's nothing else comparable in London. GPE are dismissive of the yards and see them as an opportunity to deliver places and spaces for people to provide an important and delightful addition to pedestrian movement. But the yards are a remarkable survival. They illustrate the way the High Street developed from long and narrow burgage plots, where frontage buildings were serviced by the long plots behind. The yards always had a backland and subservient character. King's Head Yard provides a good illustration of the different layers of history of the yards. The narrow enclosed space, accessed through an opening of the High Street, is a visual reminder of the burgage plots, which have informed the rhythm and scale of the High Street frontage buildings. The King's Head pub, Grade 2 listed, replaced one of the medieval coaching inns and thus provides a reminder of how the yards were used in their heyday before the arrival of the railways. The facade of the former hop sample rooms illustrates a later layer of history, the Victorian repurposing of the yards for commercial activity. The yards may not be the most visually attractive places, but focusing unduly on that aspect, as Mr. Alford has done, misses the point about what makes them so significant. The conservation area appraisal records that the street forms and layout of the conservation area contribute fundamentally to its character, and the yards are referenced several times within the appraisal of the area's character and appearance. Mr. Young was not romantic about King's Head Yard. He acknowledged that the 1980s New City Court development had not been particularly sympathetic, with facadism becoming very clear in certain views, and the service yard in particular noted as detracting from the special character of the yard. Nevertheless, the 1980s development did respect the fundamental urban grain. The yard remains narrow and enclosed, with the hop sample rooms facade providing a complementary setting to the Grade 2 listed pub and serving as a reminder of the historical development of the yard and the wider area where the hop trade flourished during the Victorian period. The hop sample rooms facade is noted in the conservation area appraisal as making a positive contribution to the character and appearance of the conservation area, and Mr. Stewart concurred with this view in his assessment. Turning to the High Street, the conservation area appraisal notes that given the eclectic mix of materials and details reflecting its evolution over a long period, contrasting with the Georgian world of Bloomsbury, the overall identity of the conservation area is as much to do with scale and form as with materials and detail. The conservation area appraisal contains numerous references to the 3 to 4 storey scale of existing development on Borough High Street. It conveys a clear message that this scale and form of development is important to the character and appearance of the area and is part of what makes it distinctive. This is shown to be true when one considers the dramatic difference in form and scale between the area within the conservation area boundary and the area immediately outside it, where Section 72 does not apply. Mr. Young observed that seeing the varied but low heights and variety of architectural styles provides an insight into how ancient the High Street is. The Shard Place, the News Building and Guy's Hospital Tower can all be seen to rise up well above the consistent 3 to 4 storey buildings of the High Street from various locations, albeit they're seen at an appreciable distance. As Mr. Young explains, these buildings create a conspicuous visual distraction and have harmed the character and appearance of the conservation area. Existing development in the backlands of the conservation area does not protrude above the High Street frontages. This point applies to the new City Court Office building as well. Whilst it has a variety of negative features, it remains recessive in most views and does not disrupt the appreciation of the consistent scale of the High Street. Moving on to St Thomas Street, a consistent scale of approximately 4 storeys is also a key feature of the St Thomas Street sub-area of the conservation area. This part of the area is very different from the High Street. The area appraisal notes the restrained quality and consistency of its architecture and the conservative established tone. St Thomas Street is much more of a set piece, with all of the buildings being associated with the development of St Thomas Hospital to the north and then Guy's Hospital opposite, built to receive the incurables. All of the buildings are based on classical principles and have a civic or domestic and not commercial character. There is uniformity of scale and massing, with the exception of the former St Thomas Church at 9A St Thomas Street, which derives significance from its prominence and landmark siting. Keats House on the south side of St Thomas Street is identified in the conservation area appraisal as an unlisted building, which makes a positive contribution to the character and appearance of the conservation area. All the heritage witnesses share this assessment. It has a highly attractive and characterful appearance. Whilst only the frontage survived the 1980s development, Mr. Stewart agreed that this fact is not immediately obvious. In Mr. Young's words, Keats House in its present form does everything it needs to do in terms of the conservation area. It's always been attached to Conybeare House, reflecting its history as a building erected by Guy's Hospital to provide accommodation for medical staff. It's therefore in the right place at the moment. Its location attached to Guy's Hospital illustrating the historic association between these buildings. Mr. Young and Ms. Adams both emphasised the special qualities of this part of the conservation area, as experienced from its eastern end, immediately after arrival at London Bridge Station. This is, of course, one of the key points of arrival into the conservation area. Mr. Young described how, from this point, the visitor leaves a very modern, high-density character area and suddenly enters a completely different character area that's incredibly historic and very consistent in terms of scale of building. Ms. Adams made similar points and characterised this point of entry into the conservation area as providing a really extraordinary contrast to the spaces one has left behind. From the west end of St Thomas Street, the tall buildings at London Bridge Station appear highly prominent. The extreme juxtaposition between them and the adjacent listed buildings is clearly harmful in heritage terms. They are alien to the special architectural and historic interest of the conservation area, which underpins its designation, and they draw attention away from the restrained consistency of this part of the area. They also deprive the Grade 2 star listed former church of its landmark status. The existing new City Court building has harmed the character of the conservation area by introducing a building that bears no relation to its historic context, with very unsympathetic junctions with the historic buildings it incorporates. For these reasons, HE has no objection to the principle of redevelopment. However, Mr. Alford's characterisation of the building as a horrific missing tooth in the smile described by Dr. Barker Mills was an over-exaggeration. The 1980s building detracts from the architectural character of St Thomas Street, but it's not all bad. It maintains the consistent building line on the south side of the street, and it adheres to the scale and proportions of the surrounding historic buildings. Once again, the bulk of the office building behind remains recessive and does not disrupt the street scene. Turning then to impacts, I first deal with King's Head Yard. Both appeal schemes would open out the narrow enclosed yard to provide public realm, turning King's Head Yard into King's Head Square. It's common ground that the sense of enclosure provided by the yard is of historical significance. It illustrates the unique urban grain of the area, which is hugely important, even if the current presentation is not as attractive as it might be. The loss of this narrow street pattern and sense of enclosure is clearly harmful. Although the 2021 scheme tries to do more to recognise the enclosed nature of the yard, it's not successful. The yard would still open directly into an area of open space, and the very large and imposing entrance to the proposed tall building detracts from the sense of narrowness and enclosure. Mr. Alford sought through his evidence to draw parallels between the proposals to open out King's Head Yard and the existence of areas of open space within the appeal site shown through historic map regression. He claimed in evidence in chief that there used to be historic entry into and through the site to ease flow, but could not point to any evidence confirming the extent of historic public access into open spaces within what is now the appeal site. In any event, the key point is that whilst King's Head Yard itself changed width and alignment at certain points, it's never been experienced as part of a public square and has never led directly onto an area of public open space. Mr. Alford accepted this. There's no historical precedent for what GP proposes to do. Throughout their history, the yards have retained a secondary and subservient character, and the conservation area appraisal reflects this by advising developers to keep utility areas behind the street frontage accessed from the rear or through narrow passages under and between buildings. The yards have not been the site of principal commercial buildings and activity. This is an important aspect of their character and appearance. The proposals would invert the hierarchy of the high street and its yards by introducing a radically taller commercial building in the backlands, further damaging the special interest of the yard. The appeal schemes would also involve the demolition of the hop sample rooms facade, and given that that's accepted as an element which makes a positive contribution, its loss should be regarded as causing less than substantial harm in line with paragraph 207 of the framework. Contrary to the position advanced by Mr. Alford, the appeal schemes would not enhance the setting of the Grade 2 listed pub. In his heritage statement, Mr. Stewart concluded that the significance of this public house derives in large part from its location on King's Head Yard. The yards were the location of the original coaching inns, and the position of the current pub within an enclosed yard is illustrative of that history. Opening out the yard to create King's Head Square will undoubtedly make it easier to view the whole of the pub's facade, but it will no longer be seen within a historically appropriate setting. This is another harmful effect. Moving to the High Street, the key impact on the High Street and its range of listed buildings would be the juxtaposition of a very tall modern building in the backland against the low-level historic frontage buildings. The schemes would introduce a drastically different form of development into the heart of the conservation area. In Mr. Young's assessment, this would be jarring and incongruous. The proposed towers would be highly conspicuous and would appear to rise very close behind the historic buildings. This would affect the ability to appreciate the individual and collective architectural quality of the high street buildings. The breathing space currently provided between the heart of the conservation area and the tall buildings at London Bridge Station would be lost, reducing the ability to appreciate the depth of the long, narrow plots deriving from the medieval pattern of development. The likely effect can be clearly understood by looking at the assessed views. In his written evidence, Mr. Stewart described this type of contrast or juxtaposition as positive, dramatic and striking. However, the TVIA concludes that when seen from the War Memorial or the junction between Southwark Street and Stony Street, the proposed buildings would produce major and adverse effects. These adverse effects led to findings of harm in the Built Heritage Assessment. It is therefore common ground that the juxtaposition that would be experienced would harm the character and appearance of the conservation area. Then moving to St Thomas Street, the same type of effect would occur in this part of the conservation area. From the St Thomas Street, London Bridge Street viewpoint, Mr. Stewart concluded that the degree to which the development dominates the existing street scene is considerable, and the coherent quality of the existing view is disrupted. The eye would be drawn away from the historic buildings and towards a large modern building, which is designed to respond to the tall buildings at London Bridge Station and is fundamentally at odds with the special interests of the conservation area. Mr. Stewart confirmed that this resulted in harm to the character and appearance of the area. Although he did not accept it in cross-examination, it's clear that the same type of harm will result from the relationship between the proposals and the historic buildings from other points along St Thomas Street, including from closer to the base of the building. At all times, the viewer would be aware of the vast height of the proposed schemes, towering over the restrained consistency of the Georgian architecture, even when they were not directly looking at it. And I just want to add in at this point, Madam, as will have been clear from our evidence, Historic England agrees with the points made in the council's closing about the lack of material before you showing the full height of the proposals, including points made about View City and about the failure of the virtual reality walkthrough to look up at any point of the buildings. It means that really the models that we have in the room are the only source of information as to the full scale of the buildings, and in terms of the context of the conservation area and the contrast between those tall buildings and the historic buildings. And they do give you a clear sense, though, although they're not assessed views or anything like that, they do give you a clear sense of the nature of those juxtapositions. In views of St Thomas Street from the west, the schemes would produce the same sort of effects, which would be exacerbated by the 2021 scheme by the increased proximity between the tall buildings and the listed terrace and the increased width of the northern elevation. From this perspective, the cumulative impact of the appeal schemes, together with the consented schemes to the east of London Bridge Station, would produce the appearance of a wall of tall modern development along St Thomas Street, eroding any sense of depth behind what would become a historic facade. The proposal to relocate the frontage of Keats House is advanced not for the benefit of Keats House itself, but to allow access to the interior of the appeal site for servicing. The current preference is for facade relocation instead of dismantling and rebuilding, but the proposed conditions would allow for either method. Both methods pose risks to the historic fabric. These risks are being taken purely because of the inherent difficulties in servicing a large development within a backland site. Although the DAS presented the separation of Keats House from Conybeare House as a benefit of the scheme, once one appreciates that it was always attached to the hospital and that this relationship has historic associations, it becomes obvious that the proposed intervention is harmful. The 2021 scheme is more harmful so far as Keats House is concerned because of the introduction of a curve on the new eastern flank wall. Mr. Alford accepted that there was nothing historically authentic about this curve. It's clear from the swept paths in the appendix to the delivery, servicing and waste management plan that the curve is needed to accommodate refuse vehicles and HGVs. Mr. Stewart said that where it's obvious a facade has been stuck on a new building, that was a bogus approach to conservation. It follows that the 2021 scheme can be described in those terms because the curved wall leading into the service entrance will make it blindingly obvious that the frontage of Keats House is merely a facade, something which is not obvious at present. It's extremely hard to see how Mr. Goddard is able to regard the works to Keats House as constituting an improvement and an enhancement to the character and appearance of the building. Instead, the works are plainly harmful. And then move on to the conservation area appraisal guidelines. These are set out in section 5 of the document, and they draw on those themes that are essential to the conservation area's historical character, which new development and improvement should pay heed to. It's common ground that these guidelines should be a key consideration in the design development of any new building in the conservation area. Mr. Stewart agreed that the overall message of the guidelines was that whilst modern architecture is welcomed in the conservation area, it needs to respect the prevailing heights of the surrounding area. The guidelines could not be clearer. Buildings should remain within the range of heights of the block of buildings in which they are sited. Mr. Stewart conceded that the proposed tall buildings breached these guidelines, and this was something that should be taken into account, and that the breaches are not acknowledged in any of GP's documents. So in conclusion, on the conservation area, there's little difference between the 2018 and 2021 schemes in terms of the degree of harm that would occur. In both cases, it would be at the upper end of less than substantial harm. There's broad agreement between Mr. Young and Dr. Barker-Mills on this. Although Mr. Stewart initially claimed in his proof and evidence in chief that the effect was beneficial, during cross-examination he had to accept what was clear from a proper reading of the BHA and heritage statement: less than substantial harm would occur. Because of the various errors in his assessment, you're left with no clear understanding of the extent of that accepted harm. A line of questioning was advanced in cross-examination of Dr. Barker-Mills and Mr. Young to the effect that harm to the character and appearance of the conservation area should be considered in the context of the area as a whole, the implication being that if harm was only found to arise due to effects on certain views or in particular sub-areas, that might be characterised as being of a lower level in the context of the conservation area as a whole. Madam, I then make 3 points in the following paragraphs in response to that suggestion, which I won't read out. And I'll just conclude this section with paragraph 121. GPE seek to promote the idea that the proposed tall buildings are simply another layer of history, the contrasts of scale and style to be regarded as threads in a rich tapestry. But the Borough High Street Conservation Area is not the right fabric on which to stitch the ambitious modern office designs of global businesses. It was designated in 1968 in recognition of the special architectural and historic interest which could be appreciated through its character and appearance at the point of designation. That does not mean that the conservation area is to be preserved in aspic. Modern development has and will continue to take place within the area boundary. Mr. Young gave some recent examples of the same. But Parliament has decreed that when an area is designated as a conservation area, those who are responsible for managing development must give great weight to preserving and enhancing the special qualities which warranted its designation in the first place. If this is not done, those special qualities will over time be lost. And as the framework reminds us, heritage assets are an irreplaceable resource. They should be conserved so they can continue to be enjoyed and appreciated into the future. Madam, I'm going to take the next section on the listed terrace as read. I deal with some specific points about development in the setting and then the specific works to the fabric of the building, which arise from the listed building consent. And I make submissions on the overall impact on those buildings. And I will continue to read again on page 47 in the section about Guy's Hospital. So far as significance is concerned, Guy's Hospital is listed at grade 2 star. Mr. Young described it as a rare survival of a purpose-built institution associated with the emergence of healthcare provision in the 18th century, and said that after St Bart's, it's the most important Georgian hospital complex in London. It was one of the first public healthcare facilities in the capital, and Mr. Young regarded it as pretty incredible that it's still largely in use today for the same purpose. The listed building derives a large part of its architectural significance from its formal composition, with a large forecourt leading into quiet courtyards in a sequence described in the area appraisal as quite exceptional. There's a strong sense of symmetry and hierarchy. From within the forecourt, the neoclassical architecture can be well appreciated, and the crowning pediments on each of the 3 building ranges provide focal points, which are deliberately aligned with the central statue of Sir Thomas Guy. During the site visit, you will have experienced how the forecourt provides a real sense of calm and seclusion, which belies its location close to points of entry and exit to London Bridge Station. When you step through the entrance gates into the forecourt, there is a distinct feeling of leaving that behind and entering a really special place. This experience of arriving into the space and experiencing the ensemble of buildings is very important to an appreciation of the significance of the listed building. It's recently been enhanced by the public realm improvements associated with the conversion of Bowland House. Tall buildings nearby have affected the ability to appreciate the architectural significance of the hospital, primarily by appearing above the roofline of the rebuilt East Wing, although Mr. Young explained that this is less apparent when entering the forecourt on axis. Mr. Stewart acknowledged a harmful effect from Guy's Hospital Tower, but considered it to be only marginal. That tells you something about the reliability of his judgments. At present, important views of the original central and western ranges from the entrance gates and within the forecourt can still be seen against a clear sky, free from the distracting presence of modern development. This clear sky setting is important to an appreciation of the order, hierarchy and symmetry of the composition. It allows the architectural details to be understood without distraction. Moving through the forecourt and the colonnade, you find the inner quads. These provided open spaces for the well-being of patients, but were at the same time enclosed to provide a secure environment. Whilst there's room for improvement in their presentation, the quads provide an even greater sense of seclusion from the modern world than the forecourt. Contrary to what the panorama photograph suggests, the existing tall buildings nearby are only really apparent if you stand in the southwestern corner of the West Quad. Elsewhere, they do not intrude. Then moving on to impacts, and firstly harm from the development in the setting. This is one of those situations where a picture is worth 1,000 words. You only need to look at the assessed view towards the west range of Guy's Hospital as proposed to understand the incredibly damaging effect of both the appeal proposals. These are such stark images, they hardly require any explanation of how the harm arises. This is, of course, the case even without having an impression of the full height of the buildings from this position due to the camera's field of view. The added sense of the full height of towers looming over you could only exacerbate their utterly dominating presence. The proposals would see the Grade 2 star listed buildings flanked on 3 sides by tall buildings in close proximity. There is clear cumulative harm. Mr Stewart accepts that the introduction of either appeal scheme would result in some less than substantial harm, but in evidence in chief he said he was unable to rate it as more than really minor and found it really hard to understand how adding a new building consistent with others nearby could be said to produce a high level of harm. I've already discussed the error in his approach to existing development which has led him to this position, and it should also be recalled that his in-the-round conclusion on Guy's Hospital was reached after netting off non-heritage benefits. Even leaving all that to one side, it's obvious that Mr Stewart has drastically underplayed the degree of harm to this Grade 2 star listed building. Harm of a similar nature would also occur in views within the West Quad. Again, this is common ground. Mr Stewart's assessment confirms that the proposed examples would have a distracting effect here. Again, the effects of the two alternative proposals are similar despite their quite different designs. The increased width and greater solidity of the 2021 scheme makes it marginally more harmful here than the 2018 scheme, but both proposals would cause harm at the upper end of the range of less than substantial harm. This is a serious degree of harm. It is harm to the setting of the listed building, but also another source of harm to the conservation area. And Madam, I'm not going to read out the next subsection on light through the stained glass windows, so I'll go on to Southwark Cathedral. Significance. Southwark Cathedral is one of only 3 monastic churches to survive in London, alongside Westminster Abbey and St Bartholomew the Great. It's one of only 4 Grade 1 buildings in Southwark. The cathedral has been a religious landmark and focal point since medieval times. The large square tower with its Gothic finials was intended as a striking architectural and religious statement and a visual spectacle. Mr Young explained that church spires and towers are designed as beacons to direct worshippers to a house of God. They are a symbol of ecclesiastical authority and are meant to be dominant. This very much applies to Southwark Cathedral. It's common ground that should be the cathedral status. The cathedral status as a prominent historic landmark is an aspect of its special architectural interest, and that views of the cathedral from its setting where the tower is appreciated as a landmark contribute to the significance of the building. Those locations include Montague Close to the northwest and the views from Minerva Square included in Dr Barkamill's appendices. In these views, the silhouette of the imposing tower and in closer views the detail of its impressive architecture is seen unchallenged by visual distraction. Mr Stewart agreed that in those locations where the cathedral is appreciated as a landmark, the relative dominance of the tower and the extent to which it remains a commanding presence are relevant to the assessment of heritage impact. Once again, existing tall buildings have harmed the contribution setting makes to the significance of the cathedral as a prominent historic landmark. This is seen most obviously from locations where the Shard appears directly behind the cathedral tower. Mr Stewart conceded that the Shard had caused harm in these views. The issue of cumulative harm is again in play here. So far as impacts are concerned, it's common ground that the appeal proposals cause harm to the significance of the cathedral where they appear directly behind the tower. In his proof and during cross-examination by the council, Mr Stewart maintained that in views where the appeal schemes are seen side by side with the cathedral tower, with clear sky between, the effect was satisfactory and not harmful. Consistently with this, Mr Stewart assessed the visual effect of the proposals from the north of the cathedral as neutral and therefore not producing any heritage harm. However, when I cross-examined him further, Mr Stewart conceded that his finding that the commanding presence of the cathedral is undermined in these views amounted to a finding of harm to significance, given that the commanding presence of the tower in such views is linked to its status as a prominent historic landmark. This is a harmful effect which was not taken into account in Mr Stewart's assessment of heritage impact. The failure of Mr Stewart properly to understand the way setting contributes to the significance of the cathedral, together with other errors of approach already discussed, has again led him to underestimate the extent of harm that would be caused by these schemes. The harm would be at the upper end of the spectrum of less than substantial harm in the case of the 2018 scheme. The 2021 scheme is lower and therefore less assertive and challenging in views, although still visually distracting. It would cause less than substantial harm towards the middle of the range. The harm is to a Grade 1 listed building and so should be given very great weight. Again, it should be remembered that Southwark Cathedral is a key listed building in sub-area 3 of the conservation area. The Tower of London. In terms of significance, it is of exceptional historic and architectural importance, both nationally and internationally. Within the Tower complex are a variety of designated heritage assets, including several listed buildings, a conservation area and a scheduled monument. However, the focus of HG's evidence has been the effect on the OUV of the World Heritage Site. The tall building proposals would have broadly the same type of impact on the other heritage assets, such that a separate assessment was not felt necessary. The World Heritage Statement Management Plan contains the statement of outstanding universal value and then goes on to introduce the attributes, which are the features or relationships that express its OUV. It states that the attributes will be the focus of protection and management policies and institutional arrangements aimed at sustaining and, where appropriate, enhancing the property's OUV. In the UK, these policies and arrangements are contained in the planning system. The ability of the attributes to convey the OUV allows a judgment to be formed as to the authenticity of the World Heritage Site. If attributes are weakened or eroded, this can compromise authenticity, resulting in harm. An analysis of the attributes and the extent to which they are affected is therefore important to a robust assessment. The exercise of identifying relevant attributes and considering the effect of the proposals on them was adopted by the inspector in the Tulip decision and is the approach that both Dr. Barker-Mills and Mr. Young have followed in their assessments. Analysis of the attributes provides a structured and transparent framework for assessment. Mr. Stewart conceded that he'd not carried out this exercise, either in his proof or elsewhere. Mr. Young's proof explains which attributes he identified as relevant and how the setting of the World Heritage Site is relevant to their expression. He also discusses the effects of outstanding existing tall building development, particularly around London Bridge, on the OUV of the World Heritage Site. Although in 2003 it was decided that the Shard would cause no material harm to the setting of the Tower of London, much has changed since then. It's since been appreciated that the Shard did have an impact on the visual integrity of the World Heritage Site and that planning policies had to be strengthened to lessen the risk of inappropriate development with an adverse impact on the Tower's visual integrity. Notwithstanding the strengthening of policy, it is the case that tall buildings continue to be permitted in locations where they are visible within the inner ward. The Vinegar Yard scheme is the most recent example of this. Again, this raises the issue of cumulative harm, a point not considered by Mr. Stewart. He said in his proof that it was hard to see how the 2018 scheme could cause harm and that it can just as readily be maintained that the addition of modern buildings in the backdrop enhances rather than undermines the sense of enclosure from the outside world that is offered by the perimeter defences of the tower. The fact that Mr. Stewart considered this to be a sustainable argument is revealing. It indicates either a lack of understanding or a willingness to disregard the history of dialogue between the UK government and ICOMOS and the resulting policy developments. It's also a position which is at odds with the recent Vinegar Yard decision, where it was found that the tall building in that scheme would negatively affect the attributes of landmark siting and concentric defences. So far as impacts are concerned, the 2018 scheme would be clearly visible above the roofline of the Queen's House in the inner ward, where it would exacerbate the visual distraction caused by the existing and consented tall buildings. It would further undermine the sense of enclosure and separation felt in the inner ward and the protective function of the concentric defences. By appearing directly above the roofline, the tower in the 2018 scheme would affect the ability to appreciate the domestic scale architecture of the Queen's House, which is part of the surviving medieval remains. The tower would also be seen above the Waterloo block when seen from the Royal Mint, further undermining the physical dominance of the White Tower from this view. Because of its reduced height, the 2021 scheme would be less visible in views from the inner ward and would not be seen from the Royal Mint. A very low level of harm would be caused to the concentric defences and surviving medieval remains. The appellants claim that the appeal proposal would cause no harm is unsustainable, given the content of the management plan and the approach taken in recent decisions, including the Tulip and Vinegar Yard. Harm would occur. It would be towards the lower end of the range of less than substantial harm in the case of the 2018 scheme, and at a very low level in the 2021 scheme. However, this harm is to a heritage asset of the highest possible significance, and even a very low level of harm must therefore be given the greatest weight in the balance. Final asset to touch on is St Paul's Cathedral. Sir Christopher Wren's architectural masterpiece was designed to be seen and appreciated over considerable distances. It's listed at Grade 1. It's iconic and remains a defining feature of London's built environment. Whilst the dome is the most recognisable feature, the architectural contrast and relationship between the dome and the West Towers is highly important. A summary of significance is provided in Mr Young's proof of evidence. St Paul's has a very large setting which has been heavily influenced by modern development. The LVMF confirms that development behind the dome currently compromises the ability to appreciate the landmark. The appeal schemes are within the wider setting consultation area, where the LVMF requires that development is designed and sited so that it preserves or enhances the viewer's ability to recognise and appreciate the strategically important landmark. With specific reference to View 3A1 from Kenwood Gazebo, the LVMF states that the proposal should contribute to a composition that enhances the setting of the landmark and the ability to recognise and appreciate it. It is not accepted that the construction of a tall building directly behind St Paul's Cathedral can be regarded as enhancing its setting. Either of the proposed towers would appear directly behind the northwestern tower of St Paul's and would add to the sense of mass behind the cathedral, as well as adding to the visual severance of the west towers from the dome. The 2018 scheme would break the horizon, which would further draw the eye away from St Paul's. Again, there's an obvious element of cumulative harm. Mr Stewart maintains that the 2018 scheme would provide a clearer backdrop to the cathedral from this view. You'll form your own view on this. It's HE's position that it's more difficult to see the outline of the northwestern tower with the proposed building behind it than is the case in the existing view. Mr Young considers that the 2018 scheme would cause a low level of harm, and the harm caused by the 2021 scheme would be slightly lower for reasons set out in his proof. Although the harm is of a low level, it's to one of the nation's most cherished and highly graded historic places and must therefore carry very great weight. Dealing then with heritage benefits, Mr Goddard summarised the benefits relied on by GPE on page 55 of his proof. I've already discussed the works of the listed terrace. Well, I haven't discussed them now, but they're in the submissions, and Keats House, and the change to the setting of the King's Head pub. HE acknowledges a low level of benefit from the listed terrace works, but maintains that neither scheme would deliver heritage benefits to Keats House or the setting of the pub. Mr Goddard also advances as a heritage benefit the removal of an unattractive office building, which detracts from the character and appearance of the conservation area and the setting of designated heritage assets. HE recognises that the site does present an opportunity for enhancement. However, the demolition of the 1980s building is just one aspect of the scheme. It's highly artificial to hive it off and assess the effects in isolation from the development as a whole. The benefits which are to be weighed in the paragraph 202 balance must be those which would arise from the grant of planning permission. In this case, the grant of planning permission would authorise demolition of the new City Court building and its replacement with a tall building. These two elements of development taken together, as they must be, would not be beneficial in heritage terms. GPE accepts that the tall building would cause less than substantial harm to two highly graded listed buildings. Madam, I'm not going to read out the next section, so I will move on to the overall conclusions. The courts have confirmed that given HE's status as a statutory consultee and principal advisor to the government on matters relating to the historic environment, that its views should be given great or considerable weight by decision makers. Cogent and compelling reasons are needed before departing from HE's considered views. Here there are no such cogent or compelling reasons. HE has presented full and clear evidence on how the proposed schemes would harm 5 key designated heritage assets. Testing of the evidence has not undermined Mr Young's assessment as to the nature and extent of that harm, which has remained consistent from his first formal response on GP's proposals for this site. By contrast, Mr Stewart's conclusions of low or no harm have been shown to be unreliable, having been arrived at through an assessment process containing a series of errors of approach and understanding. He has been driven into making several concessions in his oral evidence. I said in opening that between 2004 and 2017, HE only raised serious concerns in 7% of cases involving tall buildings in London. Participation in a public inquiry is even more unusual. The fact that HE has felt it necessary to attend this event underscores how serious the concerns are and how harmful these proposals are considered to be. Growth is inevitable and necessary, but it must be sustainable. Protection and enhancement of the historic environment is a key part of that. The historic environment should not be seen as a barrier to growth, but as a necessary component of growth that is genuinely sustainable. Growth should not come at the expense of highly valued heritage. HE's guidance on tall buildings reflects these points, noting that tall building development by its nature can have transformational impacts upon a place. This can be achieved without harm to heritage, primarily by focusing on sustainable locations and avoiding or effectively mitigating impact on the significance of heritage assets. Whilst the appeal site is identified as within the very broad area in which tall buildings are expected in the Southwark Plan, the evidence has shown that a tall building simply cannot be accommodated on this site without causing a high level of harm to important heritage assets. The harm would occur because of the height of the proposed towers and their consequent visibility over a wide area and stark juxtaposition of scale locally. In other words, it arises from the principle of this form of development in this location. Whilst any harm to heritage is in principle capable of justification, the harm to Grade 1 listed buildings and the World Heritage Site should be given the greatest possible weight, and harm to Grade 2 star listed buildings and the conservation area should attract very substantial weight in the balance. It will only be capable of being outweighed by even more substantial public benefits. You will need to consider carefully whether you've seen evidence of such benefits to clearly and convincingly justify the grant of planning permission. Thank you.
Thank you very much. Okay, right. We'll break for lunch now then. We'll come back at 2 o'clock and then we'll have the closing. Okay, thank you. Okay, yeah, welcome back. So last but not least,
Thank you.
your closings, and I've
Thank you.
got a paper copy here as well.
Thank you very much indeed, ma'am. So just a few words by way of introduction. In a few words, even were it to be concluded that the 2018 and 2021 proposals would cause the extent and degree of less than substantial harm to heritage, the Council and Historic England contend would be the case, the public benefits each scheme would bring are so compelling, both planning appeals should be allowed. The associated listed building consent appeals are uncontroversial and subject to the imposition of suitably worded conditions should be allowed. So we begin in earnest with the overall development plan strategy relevant to the appeal site and proposals, and within that we start with the overall strategy. It is important to understand the overall development plan strategy relevant to the appeal site and proposals in order to set the proposals within their full and proper context. The strategy is set by the London Plan and the Southwark Plan, both of which are up to date, although the Southwark Plan was adopted after the London Plan, such that to the extent that there is any conflict between policies in the respective plans, the conflict is to be resolved in favour of the policy in the Southwark Plan. The appeal site is within the Central Activities Zone, an opportunity area, and a town centre. The development plan policies bearing on these designations resemble a set of Russian dolls, in which the message of facilitating economic growth is consistent across the larger scale Central Activities Zone, through to the opportunity area, and in turn to the town centre and the local London Bridge area surrounding the site itself. As the appeal site is within all of these designated areas, its use for office-led redevelopment would simultaneously contribute to meeting what are described by the development plan as international, national, and London-wide roles. There are also specific local roles too. A convenient starting point for understanding the overall strategy is policy GG5, the London Plan, Growing a Good Economy, the opening words of which aim to conserve and enhance London's global economic competitiveness by a series of imperatives, amongst which are to promote the strength and potential of the wider city region and planning for sufficient employment space in the right locations to support economic development and regeneration. Next is the Central Activities Zone, which is the subject of London Plan Policy SD4, Part A of which states the unique international, national and London-wide roles of the Central Activities Zone should be promoted and enhanced. Part B is hugely significant to these appeals as it provides, with our emphasis added, the nationally and internationally significant office functions of the Central Activities Zone should be supported and enhanced, including the intensification and provision of sufficient space to meet demand for a range of types and sizes of occupier and rental values. The demand-led approach, that's to say not simply to fulfil economic projections, is important. The significance of the Central Activities Zone in economic terms is underscored in paragraph 2.4.1 of the supporting text of the policy, which describes it, the Central Activities Zone, as one of the world's most attractive and competitive business locations. The emphasis is as set out in the London Plan. The message is reiterated over and over in the London Plan, thus, for example, in the supporting text at paragraph 2.4.8. As a whole, the Central Activities Zone supports a nationally and internationally significant scale and agglomeration of offices enabled by the hyperconnectivity of its public transport infrastructure. Again, the emphasis is as in the London Plan itself. This international and national importance is crystal clear, not just in Policy SD4, but throughout the London Plan. Policy SD5, offices and other strategic functions in residential development in the Central Activities Zone, specifically prioritises offices by giving office development greater weight relative to residential development, while paragraph 2.5.1 of the supporting text of the policy reiterates that the Central Activities Zone is an internationally and nationally significant office location. Again, the emphasis is in the London Plan itself. The specific policy of the London Plan dealing with offices, policy E1, makes it clear that increases in the current stock of offices should be supported in the Central Activities Zone. The same policy also provides that improvements to the quality of office space should be supported. The policy thus lends support to both quantitative and qualitative improvements in office floor space. Moving from the central activity zone to the opportunity area, policy SD1 of the London Plan aims to ensure that opportunity areas fully realise their growth and regeneration potential. Part B of the policy aims to deliver the growth potential of opportunity areas and support development which creates employment opportunities. Opportunity areas are stated in paragraph 211 of the supporting text of the policy to be significant locations with development capacity to accommodate new commercial development. It is a strategic requirement, must, under London Plan Policy GG2, to enable the development of brownfield land, particularly in opportunity areas and sites within town centres, while prioritising sites which are well connected by public transport, promoting higher density development, particularly in well connected locations, and optimising the development capacity of sites. London Plan Policy SD6, town centres and high streets, also encourages offices as a main town centre use in town centres as a way of promoting their vitality and viability. Unsurprisingly, alongside and interwoven with all of this, the London Plan also seeks to protect London's heritage, which it lauds, and I just give a few examples. These are just examples. There are several others quite apart from the bespoke heritage policies themselves. The key point we wish to stress is in applying Section 38, subsection 6 of the 2004 Act and working out what determination, whether to allow or dismiss the appeals, would be in accordance with the development plan when read as a whole. One must keep in mind, first, the London Plan has a demand-led approach to facilitate office redevelopment proposals such as ours, and it does so because it sees increasing the supply and improving the quality of office floor space in the various designated areas within which the appeal site sits as being of global, national, and London-wide significance. Secondly, the London Plan seeks to protect heritage, some of which, the World Heritage Site, is of international significance. And thirdly, to the extent that these, that's the first and second of those, pull in opposite directions in cases like the appeal proposals, as discussed later on in these submissions, the development plan reconciles any tension by recognising that public benefits can outweigh harm to heritage. The strategic policies of the London Plan are carried forward at a local level in the Southwark Plan. Accordingly, Southwark Plan Policy ST1, Southwark's development targets, sets a development target of 10,000 jobs between 2019 and 2036 in the opportunity area, out of a target of 58,000 jobs across Southwark. It also sets a Southwark target of 460,000 square metres of office floor space in the same period, and provides that around 80% of this figure is to be delivered in that part of the central activity zone in Southwark, confirming at the Southwark level the emphasis given to the central activity zone. Policy SP4 repeats these targets, but makes it plain that the 460,000 square metres of office floor space is an at least figure and therefore a minimum. This policy also treats the Southwark jobs target as a minimum at least figure. Policy ST2, Southwark's places, explains most new development will happen in the opportunity areas, and Southwark's spatial strategy to strengthen the distinctive network of diverse places so that they will continue to be successful and vibrant is, as Mr. Goddard pointed out, to be achieved as set out in the Strategic and Area Visions and Strategic Targets Policy. Policy P30 of the Southwark Plan, Office and Business Development, specifically provides that in the Central Activity Zone, town centres and opportunity areas, development must retain or increase the amount of employment floor space on site. Policy in the Southwark Plan is then further refined by way of area subdivision within the Area Vision Policy relevant to the site, being AV11, London Bridge Area Vision. The appeal sizes within the designated area are shown by the blue line on the vision map on page 92 of the plan. It is literally irrelevant that an evidence-based document dating back to 2013, the Bankside, etc., characterisation study, may not at that stage have included the appeal site in London Bridge. What counts is the adopted Southwark Plan itself. Policy AV11 variously provides that, as well as London Bridge being an area with a rich heritage and one of the UK's busiest and fastest growing transport hubs, it is a globally significant central London business district where development should attract global commerce with headquarter and local offices and support inspiring new architecture, Growth of the area's strategic office provision is a specifically identified opportunity, last bullet in the policy. The London Bridge area, including the appeal site, is a globally significant part of the engine room, as Mr. Goddard called it, of the London and Southwark economy. A specific facet of Policy AV11 provides that development in London Bridge should harness the expertise and infrastructure from King's College London, Guy's Hospital and other medical and science facilities to develop a strong, dynamic and specialised local economy that will attract new specialised services and research and promote health and well-being in the local environment. The excellent fit of our two proposals with this objective was clear from the evidence of Mr. Villiers on behalf of the NHS Trust. Just as the London plan, the Southwark plan also seeks to protect heritage, not least via its bespoke heritage policies. To the extent the drive for economic growth in the globally significant London Bridge area might give rise to tensions with heritage protection policies, we reiterate the point made earlier. One needs to look to see how the development plan seeks to square the circle. So we turn to that, the approach to competing strands or tensions in the development plan strategy. Each of our proposals derives strong and emphatic support in principle from the London Plan and Southwark Plan policies concerning the global, national and London-wide significance of office development in the 4 designated areas within all of which the appeal site lies. And yet, to the extent the proposals would cause harm to heritage, they would be inconsistent with policies in the plans which seek to protect heritage. It is hardly unusual to find policies in a development plan pulling in opposite directions. As ever, the question is whether there is accordance with the development plan when read as a whole. Mr. Goddard's conclusion is that both schemes accord with the development plan when read as a whole. How can this be? Again, there is nothing unusual in the answer, as ultimately issues like this have to be resolved by the well-understood notion of a planning balance. Fortunately, the most recent part of the development plan, the Southwark Plan, explicitly tells us how to reconcile matters. The ground is laid in Policy AV11 of the Southwark Plan, which supports a mix of inspiring new architecture and heritage in the London Bridge area. Both of our proposals include a tall building, and so turning to the bespoke policy in the Southwark Plan concerning tall buildings, Policy P17, we find in Part 3.2 of this centrally important policy to the determination of the appeals, the specific incorporation of a balancing exercise, namely, where the proposals will affect the significance of a designated heritage asset, clear and convincing justification in the form of public benefits will be required. The balance encapsulated in this policy amalgamates the point made in the first sentence of paragraph 200 with what is said in paragraph 202 of the framework, the latter of which relates where a development proposal will lead to less than substantial harm to the significance of a designated heritage asset, this harm should be weighed against the public benefits of the proposal. It is noteworthy that the tall buildings policy in the Southwark Plan contains this balancing exercise, as the reason for its specific inclusion here, rather than just leaving things to other parts of the plan, can surely only be a recognition that tall buildings are inherently likely to give rise to some or other harm to heritage. This is especially so were one to adopt the Council's and Historic England's approach of treating a tall building in the setting of a heritage asset as a distraction from, and thus harmful to the asset's significance. And even more so once one appreciates that the Southwark Plan explicitly encourages more tall buildings around London Bridge Station and Guy's Hospital, where it must surely be obvious it's impossible to build a tall building without causing such distraction. The clue is in the tall. And were there any doubt about it, the fact box on page 135 of the Southwark Plan tells us that the point of landmark significance is somewhere which is or will be the focus of views from several directions. One can hardly be a focus of views and yet not be seen in the setting of heritage assets in an area like London Bridge, which the Southwark Plan tells us is an area with a rich heritage. Suffice it to say, all roads in this case have their eventual destination in a balancing exercise. The appellant's case remains as put in opening. The cumulative, extensive and very real public benefits either proposal would bring would comfortably outweigh whatever less than substantial harm to heritage you find either of them would cause, and the same would go for any other harm you conclude would arise. It is plain wrong to suggest our approach is to sacrifice heritage in favour of growth. Instead, we simply rely on the way the development plan itself seeks to make overall sense of those of its objectives which pull in opposite directions. We move to tall buildings, and first of all, the broad area point. In accordance with Part 1 of Policy P17 of the Southwark Plan, the appeal site falls within the area where tall buildings are expected, as shown on the adopted policies map and on Figure 4 of the plan. Of course, the area shown is broad, and it is clearly not the case that any site within it is to be considered without more analysis as suitable for a tall building. The fact that the appeal site falls within the identified area is, however, the correct starting point. Little is to be gained from reflecting that Southwark Cathedral is within the area in question. One would not expect individual sites, although a more unlikely development site than a cathedral is hard to imagine, to be excluded from a broad area. Perhaps more to the point is that the council could have chosen to make it clear that conservation areas were excluded from the area, but on the contrary, they are included in it, and part of allocation 52, that's the London Bridge Health Cluster, which includes the principle of a tall building, is in fact also within the Borough High Street Conservation Area. So the relevance of allocation. It is not a prerequisite of Southwark Plan Policy P17 that tall buildings must be on a site which has been allocated as one where they may be appropriate. The policy doesn't say, but could easily have done so if that was its intention, that tall buildings can only come forward on sites so allocated. Mr. Glasgow accepted that these evidence was not to be taken as inferring that only allocated sites within the broad area were suitable for tall buildings. The correct approach is clearly, as is common ground, to consider the appeal proposals against the detailed criteria of Policy D9 of the London Plan and Policy P17 of the Southwark Plan. Should there be a conflict between the criteria in the one plan compared to the other, this is to be resolved in favour of what is said in the most recently adopted plan. Mr. Glasgow did, however, claim that the non-allocation of the appeal site for a tall building was to be seen in the light of a much fuller response from the council to the appellant's representations on the draft plan than that found in the council's site allocations methodology report, where the reasons for the non-allocation of the site for redevelopment are explained. This says no more than the site is a fragmented mixture of buildings likely to be in multiple ownership and unlikely to come forward as a whole. Redevelopment can be achieved under other Southwark Plan policies. Inaccurate though the response is in relation to site ownership, there is no suggestion in it that the site was unsuitable for redevelopment for any other reason, nor for a tall building. Now that the response of the council's officers to the appellant's representation has been provided to the inquiry, it is apparent that Mr. Glasgow was mistaken. All that the response says is that redevelopment of the site can be brought forward through other development management policies. Again, there is no suggestion here that the appeal site is unsuitable for redevelopment with a tall building or otherwise. Equally, nothing in the evidence-based material for the Southwark Plan carries any force in deciding what is to be made of the non-allocation of the appeal site in the plan. The draft supplementary planning document showing the appeal site to lie beyond an appropriate location for tall buildings in the London Bridge area and stating that tall buildings were not appropriate in the conservation area, which dates back to 2009, was never adopted. The not dissimilar statement in the Tall Buildings June 2020 background paper that generally tall buildings would not be acceptable in conservation areas was likewise deliberately, it must be assumed, not carried forward into the adopted policy. For what it's worth, the earlier 2010 Opportunity Area Stage 1 research paper arguably shows the appeal site to lie within the area at London Bridge and Guy's Hospital campus identified as appropriate for tall buildings. This is a famous blobogram that I've been asked to specifically mention that word in closing, so I've done it, the blobogram. It's even in the footnote there. However, the long and short of the matter is that the adopted Southwark Plan doesn't say that tall buildings are confined to allocated sites and allows for their development on other sites in the broad area identified in the plan, including sites in conservation areas. It would be odd were it otherwise, given the council's decision to approve Shard Place, which is in the same conservation area as the appeal site, nor was Shard Place identified in the draft SPD as a suitable site for a tall building. Rather than banning tall buildings in conservation areas, Southwark Plan Policy P17 adopts the approach of requiring any harm to heritage to be weighed against public benefits. What about a cluster? There can be no doubt the Southwark Plan recognises the existence of a tall buildings cluster in the vicinity of London Bridge Station and Guy's Hospital. This is made unequivocally clear in the reasons for policy P17. These state, paragraph 7, that the riverfront areas of Blackfriars Road, Bankside and London Bridge provide an established height for tall building clusters set back from the river, with a number of prominent buildings visible on the skyline, including Guy's Hospital Tower, London Bridge Place, that's the News Building, and the Shard. The Shard, which stands at 309.6 metres, has formed a new pinnacle within the existing cluster of tall buildings around London Bridge Station and Guy's Hospital. This tall building has redefined the skyline of the area, making London Bridge a focus for new tall building development. Although he eventually accepted the obvious point that the Southwark Plan acknowledges such a cluster at London Bridge Station, Mr Glasgow's initial reluctance to concede as much was puzzling. This was based on the initial CABE response to the 2018 scheme in their letter of the 1st of June 2018, which questioned whether the existing morphology can meaningfully be called a cluster. CABE's musings on the subject are all very interesting, no doubt, but the Southwark Plan's explicit recognition that there is indeed a cluster here is determinative. CABE's view was in any event not without its ambivalence, insofar as their letter also expressed the view that the council should define in a plan where new tall buildings might be appropriate. For example, as a series of punctuations along St Thomas Street, in which case the proposed tower at New City Court might form the western end stop. Their second response later that year takes matters no further, and again the key thing is what the Southwark Plan has to say on the subject. Another somewhat odd aspect of Mr Glasgow's evidence was the suggestion in his proof that there were two distinct clusters, one around the Shard and the other farther to the east along St Thomas Street, a suggestion that was modified in his oral evidence to do different families of buildings as opposed to two clusters, one family being the glassy tall buildings of the Shard, Shard Place and the News Building, all by the same architectural studio, the other being more a bunch of friends in different architectural styles farther east along St Thomas Street. In any event, one only has to look at the diagrams in Mr Alford's proof, I give the references, and the model showing the existing and approved tall buildings to appreciate that there is a cluster of tall buildings here and that it is one cluster. There is no evidence to support Mr Glasgow's further related claim that the St Thomas Street allocations were intended to curate the cluster by locating it as far away as possible from heritage assets. In this regard, we note that the notion in the Tower of London World Heritage Site Management Plan that the area to the east of the Shard can accommodate substantially tall buildings without their being visible from the inner ward has proven to be wrong, as demonstrated by the cumulative view to Mr Stewart's proof. Each of the consented tall buildings on allocation 53, that's Capitol House and Edge, and the tall building in allocation 54, approved by the Mayor, that's Vinegar Yard, would be visible from the inner ward. Further, each of the allocations for tall buildings explicitly draws attention to heritage constraints, and there are 4 of those in this area, which is hardly surprising, as one of the allocated sites is Guy's Hospital itself. The Southwark Plan clearly promotes a cluster of tall buildings in the London Bridge area. This is driven by the very ambitious development proposals for the London Bridge area found in AV11. It's founded in the recognition that the redefinition of the skyline of the area by development of the Shard has made London Bridge a focus for new tall building development, and is reflected in the London Bridge allocations 52, 53, 54 on St Thomas Street and Colechurch House, which is number 55. I'll just pause there, ma'am. Colechurch House, you'll know, ma'am, obviously isn't a house. It's a building just by the southern end of London Bridge, and the proposals to replace the existing Colechurch House are the white buildings just behind the camera there, as you, okay, I'm sure, detected.
Yeah, I know where that is. I Good. Will, as requested, as well, yes, have a look at the models before we finish.
Indeed, so, ma'am, yes, if you could, yeah, if you could. So that's Colechurch House, or the proposal to replace it. It's important to appreciate that the approach of the Southwark Plan in its promotion of a cluster of tall buildings here has been developed against the context of the increased protection to World Heritage sites, including the Tower of London, embodied in Policy HC2 of the London Plan. The present case is very different from the Tulip decision in this respect. Would either proposal in this case form part of the cluster of tall buildings recognised in policy P17 to exist around London Bridge Station and Guy's Hospital and promoted in the Southwark Plan? It's obvious it would. The proximity of the proposals to the Shard Place and Guy's Hospital Tower makes it unrealistic to suggest otherwise. The appeal site is diagonally across the street from Shard Place, the walk between them being some 30 seconds. The approved tall buildings would form the foothills of the cluster to the east along St Thomas Street, and they extend considerably further from the Shard than would the proposed tall building on the appeal site. Ours would be 118 metres from the centre of the Shard, whereas the Vinegar Yard Tower approved by the Mayor would be 238 metres away. Were the cluster to be left as it is, or as it would be with the approved schemes, it would, as is put in cross-examination to Miss Adams, and as Mr Goddard observed, be pretty lopsided. As Cabe suggested, a tall building on the appeal site could be regarded as the western stop of the cluster. I turn to the cluster conundrum. There's a Kit Katism for you, if ever there was one. The same issue of how to reconcile the development plan putting in opposite directions, as already discussed in the submissions, also arises when considering how the promotion of a cluster of tall buildings at London Bridge fits with heritage considerations in the light of a battery of policies expressed in varying degrees of strictness concerned with protection of the historic environment. The latter include in the London Plan policies HC1, Heritage Conservation, HC2, World Heritage Sites, and in the Southwark Plan P19, policy P19, listed buildings and structures, 20 conservation areas and 24 World Heritage Sites. As said, tall buildings will almost inevitably give rise to some adverse heritage impacts, particularly if one adopts a distraction amounts to harm equation. Again, the resolution of the conundrum is to be sought in the planning balance. Policy P17 of the Southwark Plan provides as much in its Part 3.2. In so providing, it not only acknowledges the likely risk of some conflict between the development of tall buildings and heritage interests, but also puts forward its solution in incorporating a planning balance test expressed by way of a requirement for clear and convincing justification for harm to heritage significance in the form of public benefits. A similar approach is taken in the London Plan, which in the Tall Buildings Policy D9, Part C, 1D, provides proposals resulting in harm, that's to the significance of heritage assets, will require clear and convincing justification, demonstrating that alternatives have been explored and that there are clear public benefits that outweigh that harm. The approach is similar but not identical because this criterion refers to demonstrating that alternatives have been explored in addition to the public benefits outweighing the harm. The appellant's case is not only as the balance of harm and benefit to be struck favourably to the appeal proposals, but also that alternatives have been explored, as to which more later. It is acknowledged that London Plan policies HC1, heritage generally, and HC2, the World Heritage Site, do not contain a criterion which would allow public benefits to be weighed against harm to heritage, but as said, the Tall Buildings Policy D9 does in respect of heritage generally, albeit in the next part, sub E, there is a criterion that tall buildings must preserve and not harm the outstanding universal value of the World Heritage Site and the ability to appreciate it, with no acknowledgement that public benefits can outweigh harm. Southwark Plan Policy P19 listed buildings at the end of the policy would allow for public benefits to be weighed against harm, as would Policy P20 conservation areas, whereas Southwark's Policy P24, the World Heritage Site, does not do so. However, the approach in the most recently adopted plan, namely the Southwark Plan, must prevail, and as said, the bespoke tall buildings policy in the Southwark Plan, Policy P17, Part 3.2, explicitly provides for the balancing exercise between harm to heritage and public benefits. In so doing, it does not carve out and exclude World Heritage Sites from this. Even had it done so, the decision maker would be required under the material considerations part of Section 38, subsection 6 of the 2004 Act to apply paragraph 202 of the framework, which necessitates the weighing of harm to heritage, any designated heritage, including World Heritage Sites, against public benefits. In other words, whatever the route taken, all roads lead to the balancing exercise. An example of the approach we describe is not far to seek and is found in the Mayor's approval of the Vinegar Yard proposal. The Greater London Authority report on this proposal itemises occurrences of less than substantial harm to several heritage assets, including the Tower of London, which it considered were at the low to moderate end of the scale, but concluded, notwithstanding the considerable importance and weight attached to this harm, that the public benefits delivered by the scheme would clearly and convincingly outweigh the heritage harm. The report also concluded that despite the breach of a number of heritage protection policies in the development plan, and thereby partial conflict with it, the proposal was adjudged to accord with the development plan overall. Turning then to this issue of a point of landmark significance, Southwark Policy P17 provides that tall buildings must be located at a point of landmark significance. The fact box at the end of the policy states that the point of landmark significance is where a number of important routes converge, where there is a concentration of activity, and which is or will be the focus of views from several directions. Judged sensibly against the fact box, a tall building on the appeal site would be at a point of landmark significance. The fact box is not to be read as if it was a statute. An overall planning judgment is required. The microscopic location of a point of a convergence of routes at Barclays Bank on the corner of St Thomas Street and Borough High Street, putting cross-examination of Mr Alford, in which he correctly resisted, illustrates the overly prescriptive and artificial nature of the line of reasoning employed by the council. The wider area of this junction, including the appeal site, sensibly represents a convergence of a number of important routes for the purposes of the fact box, especially when direct access to the London Underground station, separated from the appeal site by the thickness of only a wall, which it's proposed to remove, is taken into account. St Thomas Street itself is also such a convergence, not least in the sense of routes by rail and tube. The concentration of activity around the area of the junction and along St Thomas Street is not seriously to be doubted. And it's hardly consistent with the council's case complaining about the visibility of the tall buildings we propose to imply that either tall building will not be the focus of views from several directions when their objection appears to rest on the proposition that they will be. If that strand of the council's reasoning which considered Fielden House, Shard Place, to be a point of landmark significance because it was, to quote the officer's report, located at a significant river crossing, that's to say, London Bridge itself, if that were to be applied to the present case, the appeal site is a point of landmark significance too. It would be odd and plain wrong to conclude that whereas all the tall buildings along St Thomas Street from Vinegar Yard to the east to Shard Place to the west have been considered to be located at a point or points of landmark significance, the appeal site, which is that much closer to the junction of St Thomas Street and Borough High Street and London Bridge itself, and is on the other side of a wall from a tube station, is not. That really wouldn't make sense. Turning to townscape and design, as submitted in opening, the townscape in the vicinity of the appeal site has undergone and continues to undergo huge transformation, which taller buildings are an ever-increasing characteristic, bringing with them contrasts in scale and architectural style, which are all part of the area becoming a globally significant business district. It is our case that each of our proposals constitutes exemplary architectural and design quality. Either of the proposals would, as Mr Stewart explained, enhance the character and appearance of the area in townscape terms, with any adverse effects greatly outweighed by the beneficial effects. Striking new buildings, which would be handsome and delightful, in the words of Mr Alford, would replace the poor quality and dated 1980s office building. Generous, new and inviting public realm would be created, and the historic Georgian terrace would be sympathetically restored. In the circumstances of the present appeals, and the extensive tall building development which has already taken place and been approved in the London Bridge area, leading to an intermingling of the old and new, we say that the contrasts that would be produced by juxtaposition of each of the tall buildings proposed in their lower scale immediate context would be appropriate. In considering this, it is important to keep firmly in mind that the Southwark Plan sees the very area within which the appeal site lies as a focus for new tall building development, and mandates, should, a mix of inspiring new architecture and heritage in the London Bridge area where the site sits. Both appeal schemes would be a perfect fit with this. We referred in opening to the contrast in scale and style where tall buildings here in Southwark are found cheek by jowl with, and in the closer and wider settings of heritage buildings and areas, and describe these contrasts as threads in a rich tapestry woven by us in our era, paragraph 49 of the National Design Guide under the heading of context very much encapsulates the same idea. Today's new developments extend the history of the context. The best of them will become valued as tomorrow's heritage, representing the architecture and placemaking of the early 21st century. The Council's design and townscape objection to the present proposal suffers from a number of significant problems. First and foremost, it is advanced via the relevant witness, Miss Adams, in a way which lacks any proper balance. In opening, we've described her proof as a hatchet job. Miss Adams' oral evidence lived up to our characterisation. She asserted that, save for the restoration of the Georgian terrace, there were no good things to be said about either of the proposals. None. This is an untenable view, which calls into question the objectivity of our evidence, quite apart from the inherent unlikeliness of the president of the RIBA and a leading architect of proven distinction producing two consecutive duds on the same site. It doesn't even reflect the Council's own pre-application position in respect to the 2018 scheme, where, amongst a range of criticisms, it was at least recognised that benefits flowed from the generous and well-proportioned square to the rear of the tube station and a new public space on St Thomas Street, and that the proposal also improves the setting of the Grade 2 listed King's Head Public House, improving views of its frontage and making it a feature of the new square. Secondly, the mainstay of Miss Adams' critique was the absence of any design story she was able to detect for the schemes, and the related claim that it appeared that the design journey had started with a tower, rather than this resulting from the consideration of alternative forms of development. On a fair reading, Mr. Alford's proof narrates the design story, and remembering the absence of any such story was not made as a criticism of Mr. Alford's work, for example, as set out in the design and access statement for each scheme before Miss Adams came along, Mr. Alford's oral evidence provided a superabundance of additional narration of the design story. Nor did the design process start with a tower as a given. Mr. Alford explained how a do minimum, that's our phrase, option, in terms of adapting the 1980s building was considered extensively over a number of months, but concluded to be an unviable proposition. It was put to Mr. Alford by the Council that there was no independent report before the inquiry demonstrating this, but why should there need to be? Mr. Alford's own informed view on that issue, forming as it does part of the essence of his practice as an architect, expert in the development of office buildings, is more than sufficient. It is also important to remember that the Council had never previously challenged this position. A further option considered before the idea of developing a tower was generated was the ocean liner, quote-unquote, concept, an 8 to 10-storey redevelopment filling the site, as Mr. Alford also explained. This was rejected on the basis that it wouldn't deliver public benefits, and a tall building solution was settled on after about 9 months, to release space on the site for public realm and associated public benefits. We interpolate at this point that the consideration of the do minimum and the ocean liner options constitute, for the purposes of the London plan policy, the relevant part of it there, the exploration of 2 further alternatives in addition to the 2 schemes before the inquiry. Now, thirdly, another main theme of the Council's case advanced through Miss Adams' evidence that the design process of the schemes has been inadequately informed by context lacks any merit and was refuted in Mr. Alford's proof and in his oral evidence. Enormous attention has been given to context, including study through map regression of how the appeal site and its context have changed over time, detailed consideration of the historical evolution of King's Head Yard, and exhaustive analysis of the changes that have brought about the Georgian terrace as it now appears, and how it relates to the earlier development of the buildings on the north side of St Thomas Street. Consideration of context has gone far beyond looking at the architectural language of surrounding buildings and structures, although this exercise has also been carried out with thoroughness. New buildings in the area have also been appropriately considered as part of the context. Turning to the case of Historic England, it raises a point of principle in relation to design insofar as it includes the proposition that design cannot be regarded as good if it causes unacceptable heritage harm. Now, we invite rejection of this proposition as misconceived. It is premised on a non-existent freestanding notion of unacceptable heritage harm, whereas the true position is that certainly in the case of less than substantial harm caused by a proposal, the proposal only becomes unacceptable if the conclusion is reached that the heritage harm is not outweighed by the public benefits of the proposal. The acceptability or unacceptability of heritage harm resides not in the harm itself, as a proposition would mistakenly have it, but is the product of the necessary balancing exercise, Mr. Young was unable to defend the proposition, and it plainly cannot be said to be the case that unacceptable heritage harm could mean, as he suggested, heritage harm which is unacceptable to historic England. As it is, we submit that the requirements of the relevant design policies have been met in this case. Each scheme represents optimisation of the appeal scheme's capacity by following a design-led approach in accordance with policy D3 of the London Plan, the generous public realm provided by each scheme, and their relatively modest area uplifts. We give the multiplications seen against the generally much larger uplifts of the other modern tower schemes in the vicinity belie any suggestion of maximisation rather than optimisation. The same is also true of the evidence given by Mr. Alford that the quantum of new office floor space, which had become fixed under the 2018 scheme through the evolving design process over some 4 years, was on the cusp of viable. The design requirements of policy P17 of the Southwark Plan are met. Without itemising each and every one of these requirements, we submit that each of the schemes have heights that are proportionate to the significance of their location at a point of landmark significance and the size of the site, make the necessary positive contributions to local character and townscape, manifest exemplary architectural design, provide generous public realm, including elevated gardens, avoid harmful environmental impacts, maximise energy efficiency, prioritise the use of sustainable materials, and to the extent that there is harm to designated heritage assets, provide clear and convincing justification in the form of public benefits. Each proposal represents the inspiring new architecture demanded by Southwark Plan Policy AV11, and neither infringes the requirement of that policy that the Shard remain significantly taller and more visible than surrounding buildings. Miss Adams' contention that the proposals would challenge the dominance of the Shard shouldn't be accepted. Any new tall building in the near vicinity of the Shard would inevitably obstruct its visibility to some degree when viewed from a particular angle at a particular point. For example, to the effect of the News building when seen from London Bridge. The requirement cannot be read to proscribe that which would be impossible to achieve. The Shard would remain both significantly taller and more visible with either of our proposals. Mr. Alford correctly made the point that the Shard was particularly prominent in mid and more distant views. Influences in relation to railway infrastructure and warehouses drawn from outside sub-area 4 of the conservation area in relation to the former, and from a different conservation area, Tooley Street, in relation to the latter, have been appropriately relied on to influence the architectural language of the proposals. Mr. Alford explained that the wider area was appreciated by those within it as a continuous urban experience, rather than entry into and exit from distinct conservation area sub-areas with a series of relationships and views. The railway infrastructure can be seen from sub-area 4 anyway, and of course each proposal would be seen from outside the conservation area in any event. The approach taken with the appeal scheme was, Mr. Alford said, not to dilute the distinctive character and appearance of sub-area 4, but to enrich it, just as Shard Place has done likewise. The assertion of the Council there was a shortcoming in the design process in respect to the 2021 scheme and that it wasn't taken to CABE for design review, resulting in a breach of part of one of the London Plan policies, is a bad point. We've missed out the policy number there, haven't we? So we'll just find that. We'll find it in our notes, paragraph 67 of the closing there. It's a bad point. As Mr. Goddard explained, the Council didn't suggest that the 2021 proposal should go to CABE. Instead, a local design review panel was suggested for a date which wasn't convenient, and the Council never returned with an alternative date, but later made it clear in an email to the appellant that the 2021 scheme would not be supported in any event. Importantly, the 2021 scheme arose from the many years of extensive consultation which preceded it in respect to the 2018 scheme, both before and after the submission of the 2018 application, and was primarily directed at addressing the criticism of the relationship between the 2018 scheme and Southwark Cathedral. The 2021 scheme achieved at least some success in that regard, as whereas the Cathedral object to the 2018 scheme, they support the 2021 scheme. Finally, on the subject of townscape and design, it's worth remembering that the Council's statements of case in respect of each scheme contend the scale and design of the proposed development is not appropriate for this site and its surrounding context, resulting in harm to the townscape and local character. Our emphasis there on the words resulting in harm. The opponents disagree, and strongly so. But if the conclusion is reached that there would be harm of the nature alleged then, along with any harm to heritage, it would need to be weighed against the public benefits to the proposals. The opponent's case is that the public benefits to the proposals are so compelling that they would outweigh not only harm to heritage, but also, if any is added to the weighing scales, harm to townscape and local character too. The reality is that much of the case made against the proposals in terms of harm to townscape is based on the same or similar points to those made in relation to harm to heritage. They certainly morph into each other. And if, as we say, the public benefits are sufficient to outweigh harm to heritage, bearing in mind the particular weight which is given to any such harm, it's hard to see how they would not also outweigh harm to townscape. Now, the missing policy reference in paragraph 67, third line, is D3. So turning to heritage and matters of approach, the uncontentious starting point in approaching heritage issues is that the question of whether there is harm to a designated heritage asset is to be answered by asking whether there is harm to the significance of the asset. As neither the Council nor Historic England contend that there is substantial harm to any heritage asset in this case, it's of obvious relevance to understand where the boundary lies between substantial and less than substantial harm, in order that the magnitude of harm this latter concept signifies can be more clearly understood. It is common ground with both the Council and Historic England that substantial harm is a high test as provided in paragraph 18 of the relevant part of the PPG, which states, and we then quote it, and you'll be very familiar with it, ma'am. Paragraph 71, taking the example of works to a listed building as a proxy for impacts on heritage assets in general, it can be inferred from paragraph 18 of the PPG that less than substantial harm is generally to be understood as harm which doesn't seriously affect a key element of the asset's special architectural or historic interest, that's to say, its significance. An essentially similar point emerges from the way in which matters were put by the court in the Holocaust Memorial case, where the judge concluded that the inspector in that case had interpreted the relevant test for substantial harm as being the serious degree of harm to the asset's significance. This formulation, equating as it does substantial with serious, was correctly accepted by counsel for the claimant on the basis that it reflects the wording of the PPG and is an expression of government policy, and it was adopted by the court without demur. Surprisingly, Mr. Young, having accepted that paragraph 18 of the PPG was an appropriate way of distinguishing between substantial and less than substantial harm, was not then able to say whether he had reached the conclusion in the present case that the harm was less than substantial, either because it did have a serious effect, but not on a key element of the asset's significance, or because it did have an effect on a key element of the asset's significance, but that effect was not a serious one. Perhaps more surprisingly, Mr. Young agreed with the formulation in the Holocaust Memorial case that substantial harm involves serious harm to significance, with its inevitable corollary that less than substantial harm doesn't involve serious harm, yet was quite unable to explain how it was that he was able in his proof to maintain, as he does, that the heritage harm is serious, notwithstanding it's less than substantial. This is a contradiction in terms, as it involves this proposition. Substantial harm means serious harm. The harm here is not substantial, but it is serious. Turning next to the question of calibration of the degree of harm arising in a case of less than substantial harm, that calibration must be against the whole heritage interest of the asset. It is therefore contextually relevant in this regard, where impacts are indirect, affecting setting only, to keep in mind there are no direct impacts. This leads us to the Somerset House decision, which contains a clear analysis of how setting impacts can be approached. The analysis is of particular relevance in this case, in that all the heritage impacts here, apart from the beneficial interventions in respect to the Georgian Terrace and the direct impacts on the conservation area, are impacts on setting. The inspector reasoned in his report that in cases where the impact is on the setting of a designated heritage asset, it is only the significance that asset derives from its setting that is affected. All the significance embodied in the asset itself would remain intact. In such a case, unless the asset concerned derives a major proportion of its significance from its setting, then it's very difficult to see how an impact on its setting can advance a long way along the scale towards substantial harm to significance. That inspector rounded his analysis off as follows. It's often argued that such an approach leads to harm to the significance of a designated heritage asset being underestimated. However, what is under consideration is the impact of change on the significance of a designated heritage asset. If that change would come about as a result of development in the setting of that asset, then it is only the component of significance that the asset derives from its setting that would be affected. That is the outcome of the approach the framework takes. The Secretary of State agreed with the Inspector's reasoning in the above paragraphs. For his part, Mr. Stewart completely agreed with it. The Inspector's analysis is clear and compelling in its logic. In the Council's opening, it was suggested that the approach taken in the Summerskill House decision was different from the approach taken in the Tulip decision, and it was indicated that the Council preferred the latter, although it was recognised that the matter was one for your judgment. In the latter, that's the Tulip, the Inspector said, that Inspector there, Mr. Nicholson, said that the key point is not whether some aspects would be left untouched, but the importance of what would be affected, that is, the setting to its significance. We submit that there is in fact little difference between the approaches, and that the essential focus of each is on the contribution made to significance by setting. Thus it was that Mr. Stewart considered both that he had followed the Tulip approach, but that not inconsistently, the question of what was left untouched had figured in his consideration as relevant. He made it clear that he was not saying that harm to setting was always less significant than harm to historic fabric, but it was less with the proposals presently under consideration. Next, it's to be noted that because conservation of a heritage asset is defined in the glossary, and we quote it, and that paragraph 199 of the framework provides that great weight should be given to the asset's conservation, it's necessarily not just that great weight should be given to harm to an asset's significance, but also that heritage benefits arising through enhancement of significance should carry great weight. And we then talk about this a bit, but I notice that both my learned friends' closings accept the point, so I won't read out the rest of paragraph 80. As for paragraph 81, as for paragraph 202 of the framework, we add the satisfaction of the balancing test it contains supplies the necessary, clear and convincing justification required by paragraph 200 of the framework for harm to the significance of a designated heritage asset. There is but one test, not two. Finally, in respect of matters approach, it was accepted in cross-examination, and I give the references, that because a conservation area is by definition an area-based asset, assessment of the effect of the proposal on a conservation area is to be undertaken by reference to the area as a whole, and in this particular case, by reference to the whole of the conservation area, rather than by reference to the particular sub-area in which the site lies. This is now disputed in Historic England's closing. I draw attention to the treatment of the subject in paragraph 207 of the framework, which explicitly refers to assessing the conservation area and indeed World Heritage Sites as a whole. A few words about the role of photographs and visualisations. Photographs seeking to capture views of the existing situation and visualisations of the proposals are a tool to provide assistance, but are no more than that, and do not provide a substitute for going out on site. They cannot capture the human viewing experience, and as Mr. Stewart explained, the points from which the photographs are taken and the visualisations provided are not in the majority of cases views proper, but simply photos taken from places where you would or might see the proposed tall building in either scheme. And of course, views change and evolve in a dynamic sequence as the viewer proceeds on whatever may be his or her way. Some caution is therefore to be exercised in considering the photographs and visualisations. A case in point is provided by the photographs from London Bridge, which do not convey the true on-site experience in which tall buildings behind Southwark Cathedral are, as things presently stand, readily apparent to the viewer walking from north to south across the bridge. As for appropriate heritage input into design, there has been appropriate, robust and reliable, if you like, specialist heritage input into the design process of the schemes. Mr. Stewart's fulfilled that role. Nothing is to be made of the fact that he only came on board as part of the design team in 2016, by which time the principle of a tall building on the site had become a fixed part of the proposals. The evidence of Mr. Alford shows that his practice already themselves had a good understanding of the heritage significance of the appeal site surroundings, but as Mr. Stewart also explained, the project team had already had, before his involvement, the benefit of the services of Peter Riddington of Donald Insold Associates, a preeminent heritage specialist since retired. There's then just a couple of paragraphs about Mr. Stewart's approach to assessment. I won't read 86 and 87 out, they're there as a brief summary of the position he explained. At 88, the main heritage assets, we turn next to consideration of the main heritage assets where harm could potentially arise. We continue to rely in full on the evidence of Mr. Stewart and his proof and rebuttal in relation to the main and all other heritage assets. We consider and do not think it should be contentious that the restoration of the Georgian Terrace is a heritage benefit, which should accordingly be afforded great weight. Now, Table 1 for the 2018 scheme and 2 for the 2021 scheme in the Heritage Statement of Common Ground very helpfully sets out a side-by-side comparison of the presence or absence of harm and the extent of any less than substantial harm as concluded by each of the three expert witnesses on heritage. As has been made clear via Mr. Goddard's evidence, even where Historic England's and or the Council's assessments of the presence and extent of less than substantial harm to be preferred across the board to Mr. Stewart's, the appellant submits the public benefits individually and cumulatively of each scheme are so compelling that they would outweigh all such harm, acknowledging, of course, that the presence of heritage harm creates a strong presumption against the grant of permission. The presumption is rebuttable by public benefits, and that considerable importance and weight, indeed great weight, is to be given to heritage harm, just as it is to heritage benefits. In the following sections, we briefly summarise Mr. Stewart's evidence on each of the assets. As it is simply a summary of his evidence, I'm not going to read this all out aloud. There's just one passage in a particular place, and there are two passages I'm going to draw to attention, one of which I'll read, but I'll take much of this as read. So in relation to the conservation area, if you go through to page 31, paragraph 93, I won't read this, but I'll just very briefly explain that you'll know and recall I say at the end of this paragraph, that Mr. Alford was teased for describing the yard as he did, found it, to understate it, rather dispiriting. He's been rather teased, I think, to be honest. It would be right to say that he was almost ridiculed for holding the views that he did. We just point out and quote in terms in paragraph 93 that the GLA explicitly accepts the position that the yard has its shortcomings, generally unattractive, etc., etc. I won't read this all out aloud. It's all quoted for you there, just to show that Mr. Alford isn't alone in his views on the subject. Moving to Guy's Hospital, there's a passage of more general application, which is written here in the context of Guy's, but it applies across the piece. So I will read this out. It's at paragraph 95. And just picking this up in the second line of paragraph 95, we say that the Council and Historic England, we would say, are over-attached to notions of visual competition and distraction and the like. We appreciate that concepts like these feature in Historic England's good practice advice note, the setting of heritage assets, and indeed elsewhere, but they are not the conclusion of the analysis required by the framework. If it is concluded that there would be visual competition, distraction, drawing the eye away, harm to the ability to appreciate the significance of the asset or any such, whether in relation to Guy's or any of the other heritage assets within the setting of which the proposals would stand, one must still go on to work out whether this effect would cause harm to the significance of the asset. The framework repeatedly and exclusively refers to impact on or harm to the significance of a heritage asset, and I give all the references. Now, to be clear, we acknowledge that visual distraction or such like, whichever of those ways of putting it you find, if that's found, then that's a material consideration. Our point is that it is simply a step in the analysis, but not its conclusion. One must be careful not to assume that visual distraction or similar would harm the heritage significance of the asset in question. One must ask and answer the questions, does it? And if so, how? So then after that, I'll just take these sections as read for the various assets, and I will pick the reading up again, or at least I'll have a pause at page 36, where we finish our brief summary of the evidence that's been given on our side about these various assets. We turn to other issues, and just as with my learned friend for the council, and his closing, I won't read out the section on servicing. It's extensively set out there. If you ever wish to subject yourself to reading all these minutiae, it's all there, ma'am. At least that's our attempt anyway. And then at page 39, we note that the issue of BREEAM is no longer an issue, if you like. climate change and sustainability can all be secured satisfactorily, and daylight and sunlight. Again, I won't read this out, but just at the end of paragraph 115, we just draw attention to Mr. Goddard's judgment call and his evidence that the daylight and sunlight losses in the issue have no material part to play in the overall decisions. And so we turn really to, as far as we're concerned, is the crux of the matter, public benefits. The public benefits either scheme would bring cumulatively are enormous. This is paragraph 116 on page 40, by the way. The range of benefits as substantially agreed is set out in the planning statement of common ground, and the real point of departure between ourselves and the council is the weight to be given to each benefit in turn, and then to their accumulation overall. We single out some of the more important differences below, but we rely in full on the weighting of Mr. Goddard's evidence. Helpfully, there is now an agreed statement that sets out side by side, for easy comparison, the weight given to the benefits by Mr. Goddard and Mr. Glasgow. Our case in a nutshell is that Mr. Glasgow has talked down the benefits. Also, it's important to include the considerable public benefits secured by the Section 106 planning obligations and the SIL payments. So we turn to the first of these really big benefits, quantity and quality of office space. Either proposal would bring about a major improvement in the quantity and quality of office space on the site. In the 2018 scheme, some 46,000 odd square metres of Grade A office accommodation, resulting in an uplift of over 33,000 square metres of office floor space across the site. 2021 scheme would provide 49,000 thereabouts square metres of Grade A office accommodation, resulting in a bigger increase of 36,000 so square metres of office floor space across the site. Either scheme would thus make a significant quantitative contribution, a bit over 7% and nearly 8% respectively, of Southwark's net minimum additional office floor space target of new office floor space in a policy compliant location. Coupled with the high quality of the new floor space to be provided, Mr. Goddard is right to attach substantial weight to this benefit. This is especially so given the across-the-board strong policy support for more and better quality office floor space in the globally, nationally and London-wide significant location within which the appeal site lies. Mr. Glasgow's attribution of only moderate weight to this benefit on the basis that strategic targets can comfortably be achieved without the uplift in floor space that the schemes would deliver is wrong in principle. Providing more floor space in circumstances where there is no cap on its delivery, the target's the minimum, is not a reason to reduce the weight to be attached to it. That is especially so in circumstances where uncontested market overview and demand analysis points to the difficulty of meeting demand for new build Grade A space in this market, with only 4% of the potential future supply having minimal entry barriers. Planned allocations do not, as Mr. Goddard said, necessarily translate into deliverable consents. The appeal site is owned by GPE, a hugely experienced and well-funded developer of office floor space in central London. Once again, one must keep firmly in mind the importance, global, national, London-wide, attached by the development plan to more and better quality office space in the 4 designated areas in which the appeal site sits, and that the approach in the London plan is to meet demand for office floor space. In the light of points like these, it really is hard to fathom how only moderate, middling weight should be given. It's self-evidently a matter of substantial weight. Employment and the contribution to the local economy. Either scheme would generate significant job creation at construction and operational stages, accompanied by worker spend in the local economy and an increase in GVA. The figures, extracted from the relevant report, are set out in Mr. Goddard's proof. The net additional full-time equivalent jobs in the operational phase, when the offices are open, more than 2,000 and 3,000, more than 2,000 and more than 3,000 in the 2018 and 2021 schemes respectively, should in any sensible analysis be seen as very important indeed. Mr. Goddard gives the benefits of employment and the contribution to the economy substantial weight. Mr. Glasgow relies on the appellants on our ES scoping report for the 2018 scheme to attach only moderate weight to the job benefits on the basis that the scoping report stated that the jobs were unlikely to be materially significant in the wider London area. However, the proposals would deliver on a single site 22% or 30% of the target of 10,000 jobs for the opportunity area. This is a sizable contribution to an important Southwark Plan policy target. Whatever may have been the view to the environmental assessors, a London-wide jobs perspective is a poor basis for a comparative judgment when specific development plan targets are set for the more immediate area of the site. Indeed, Mr Glasgow relies on local Southwark policy considerations and giving significant weight to the scheme's provision of affordable workspace. He was right to do so. Returning to the London-wide comparison, its weakness as a point is demonstrated by the fact that, as explained by Mr Goddard, given that London supports 5.7 million jobs, any scheme would struggle to make a significant quantitative jobs contribution measured against this yardstick. And he also made the fair point that the schemes could indeed be significant for jobs at a London-wide level in qualitative, if not quantitative terms, for their potential to attract occupation as a global headquarters. We say equally that there's no reason to reduce the weight given to job creation on the basis that the schemes would do no more than comparable schemes. The obverse is the case. A comparable scheme, of which Mr Goddard said there were none along those permitted along St Thomas Street in terms of extent of job creation, should also attract the same substantial weight. It's not to be forgotten that paragraph 81 of the framework provides that significant weight should be placed on the need to support economic growth and productivity, taking into account, amongst other things, local business needs, as evidenced in this case in the Cushman and Wakefield market overview and demand analysis. In terms of the public realm, the same theme of devaluation of the public benefits of the schemes is apparent in Mr Glasgow's attribution of only limited weight to the public realm that they provide, in contrast to the much greater weight, very substantial, that Mr Goddard realistically gives to this dimension of the schemes as part of his assessment of the wider topic of design quality in public realm. Mr Glasgow's assessment cannot be sustained based as it is on Miss Adams' unbalanced view that there's nothing good about the schemes. In its more balanced assessment, the GLA Stage 1 report was strongly supportive of the public realm in the 2018 scheme. The public realm is not mean, as Miss Adams would have it, but generous. 1,355 square metres of new public realm is provided at ground level in the 2018 scheme. To be added to this is the 700 square metres of the new elevated public garden, excluding the cafe. This makes a total of over 2,000 square metres of new multi-level public realm overall, which amounts to 73% of the available site area, the Georgian Terrace and Keats House not being available, of course. As it stands, the existing site provides purely theoretical public realm, taking the most generous but wholly fanciful view of 211 square metres. 1,136 square metres of new public realm is provided at ground level in the 2021 scheme. To be added to this is the 780 square metres of new elevated public garden. This makes a total of 1,916 square metres overall. In both schemes, public realm outside the appeal site boundary would also be enhanced. The elevated free-to-access public gardens in the schemes are a unique feature of the development. None of the existing tall buildings in the area has such a facility, nor are any of the other proposals coming forward on St Thomas Street delivering one. The criticism that the public realm would be too busy with people passing through to enable space to dwell is misplaced. Appropriate areas to dwell are illustrated on the space syntax diagrams in respect of both schemes. The provision of shade, which is also features as a quibble about the external public realm, although there will be plenty of daylight and reasonable sunlight, is not a bad thing, but a good thing. The fact that 54% of the public realm would be enclosed is by no means an unsatisfactory feature of the 2021 scheme, but on the contrary, represents an entirely appropriate design response in the provision of an elegant, side-lit gallery, 17 metres tall, with echoes of the highest part of the concourse reaching up to the elevated platforms at London Bridge Station. If any implications were being suggested for the success of the public realm in the 2018 scheme in the light of the decision in respect to the 2021 scheme to remove from the latter much of the retail provision proposed in the former, you need not have a concern in this regard. As Mr Alford pointed out, a good developer might well decide to address any resulting issue by cross-subsidy of uses so the public space was activated, and it would realistically be expected that activity and engagement would be curated over time by the management of the building. In addition, there is affordable retail space in the 2018 scheme. Turning then to substantial transport benefits, The low point of the Council's approach to valuing the public benefits of the schemes comes in Mr Glasgow's attribution of only limited weight to the facilitation of the creation of a new entrance to the underground station, the permeability provided by the new routes through the site, and the relief provided to crowded footways on Borough High Street, all in contrast to the very substantial weighting which Mr Goddard identifies here. We submit that Mr Goddard's position is strongly to be preferred. The new access to the underground station is another unique and exceptional public benefit of our proposals. The GLA Stage 1 report in respect to the 2018 scheme strongly supported the new station entrance and improved pedestrian access between the High Street and St Thomas Street. In CABE's response, 2018, it was observed that the panel was impressed by the proposed creation of a new entrance to the underground station, together with a new public space to activate King's Head Yard and integrate it into the public realm. The proposed development promises to seize a unique opportunity to enhance connectivity in public realm in the area. What is to explain the Council's reluctance to acknowledge the true worth of the benefit we're providing here? Seems to come down to the view expressed in Mr Glasgow's proof that the principal beneficiaries of the new access would likely be those employed within the development. This is not the case. See our document, Inquiry 24. Now, some 70% of the users of the new public realm would not be users of the new buildings. Mr Glasgow's note, today's note on the subject, attempts to cast doubt on this, although the input he queries has been agreed with TfL modellers, see paragraph 12 of his note, and importantly, Mr Glasgow's note puts forward no alternative figure of his own. On the evidence, the only conclusion open to be reached is that most of the users of the new public realm would not be people working in the buildings on the appeal side. Now, the entrance exit isn't as busy as others at London Bridge, but this mustn't be allowed to distract from the absolute numbers. We are talking about thousands of people using this entrance and exit in the busier hours. The further attempt to mount the case in cross-examination of Mr Goddard by reference to a single bullet in one of the paragraphs in TfL's representations is also to be rejected, quite apart from the fact that the large majority of the users of the new public realm would not be users of the new buildings. It is to be noted that TfL's own representations begin by stating, we quote, the new additional entrance will have the following public and development benefits, with our emphasis there. Then, of course, heritage benefits. The restoration of the Georgian Terrace represents a heritage benefit. It's agreed to be such in the planning statement of common ground. It's another benefit which is unique to our proposals in comparison to the other tall buildings built or permitted along St Thomas Street. Its omission as such from Mr Glasgow's proof is surprising. His description of only limited weight to it in the face of a requirement to give it great weight under the framework is not only surprising but simply wrong. This is another example of talking down the benefits, as we referred to in opening. Cumulative weighting and the overall balance. Now, Mr Glasgow oddly provides you with no cumulative weighting of the benefits of our proposals and wasn't prepared to do so. You'll remember I gave him at least 3 opportunities. Mr Goddard, on the other hand, does give such an assessment and attaches very substantial weight to the cumulative set of public benefits. We reiterate the submission that the combined benefits would comfortably outweigh any less than substantial harm that you find either of the proposals would cause, and that the same also goes for any other harm you conclude would arise. For the avoidance of doubt, we say any less than substantial harm that you find either of our proposals would cause, to make it clear, as did Mr Goddard, that we contend the balance should still be struck in our favour, not just if you find that our assessment of a less than substantial harm is correct, but also if you're persuaded that the assessment of the Council and or Historic England is to be preferred, or if your assessment is somewhere in between. The striking of the balance in this way would be foursquare in line with the conclusion expressed in the GLA Stage 1 report in respect to the 2018 scheme, where the conclusion was reached, notwithstanding an assessment of less than substantial harm to a number of heritage assets, that this harm would be outweighed by the wider public benefits associated with the scheme. So, penultimately, accordance with the development plan, we've already rehearsed the issue of accordance with development plan policy in various sections of these submissions. We submit that the determination in respect of each of our schemes, which would be in accordance with the development plan when read as a whole, would be to allow the appeals. Should a different conclusion be reached, we would nevertheless submit that material considerations, namely the compelling package of public benefits, would, in the language of the second part of section 38, subsection 6, indicate otherwise, such that the appeals should be allowed. On our overall conclusion, accordingly, we ask you to recommend, and the Secretary of State to allow both appeals. We ask to be allowed to add our layer of history to this globally significant business district. Those are our closing submissions. Thank you very much indeed. Ma'am, it just leaves me to say a few words. I can certainly, at the end of an inquiry where we've all been in the nicest possible way fighting each other, I think I can say something which we all agree with. I hope so. I'm sure this is right. Apart from the fact that everyone thinks I'm a great person. No, we'll leave that to one side. And that's just simply, ma'am, to say thank you very much indeed for the way in which you've conducted this inquiry. I mean, to use a Kit Katism, it's been a blast. I mean, it's been hugely enjoyable. We've all been fighting away about all these issues, which we've summarised in our closings, all of us. But the whole inquiry has been conducted, it seems to me, and I'm sure to us, in the most civilised and respectful manner, with good humour. It's been very good-natured. And a large part of that is down not simply to the players in the play, but to you, ma'am, person who's actually led this inquiry as the inspector. It really has been a very, very enjoyable experience. Whatever the outcome, and we all hope to win, of course, but whatever the outcome, it's been a very, very well, if I might say, very, very well-run inquiry. In particular, thanks also to your programme officer, who's kept everything running very smoothly indeed. I said on the first day, and I'll repeat it now, this is the best programme for an inquiry I've ever been at. It's allowed us all to call our witnesses without undue stress. We've had time to do our jobs without having to sit up all night, etc., 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 because of a tight and overly ambitious programme. Here it's been very, very civilised indeed. So, on behalf of all of us, our genuine thanks to you, ma'am, and to your programme officer.
Thank you.
And, but I'm very grateful to my learned friend for saying all of that on behalf of the bar here, as it were, and I would echo that on behalf of the council. Thank you.
Thank you. Likewise. Thank you. Well, thank you. I've got some closing remarks to make myself as well, some boring stuff and then some of my thoughts as well at the end. So I'll get rid of the, well, not boring stuff, important stuff, but the worky stuff. Me and the programme officer went up the Shard yesterday, very clear day, and looking down quite a way down, you can see the site, but it was quite good actually to see the grain of the borough conservation area and just sort of taking the area. So no, it was worth doing. And at lunchtime today, I did the TfL servicing visit as well, just round with the maps that were provided. I can't remember, I think it's INQ 21 and 22. So I've sort of mopped up everything in the site visit that needed to be done, just to make that clear. Where are we with the conditions? Because I think that's the only outstanding document separate to the obligations.
So there is a set that's been agreed between the parties. We've been working on 2018, so we'll be able to get that in. It's gone in. That one's gone in. The 2021, as we've gone to transpose them across, there are just a couple of minor differences, so we wanted to just check in with the council after those, and then we'll submit them, I'm sure, this afternoon.
Okay, great. So we'll put them down as an inquiry document rather than being a document after the inquiry closed, just to make it simple. Okay. And no one has indicated, and I don't think there will be, but are there to be any applications for costs to be made? No.
No, thank you.
Thought I'd ask, have to ask. So just some of my closing remarks. Thank you all from the bottom of my heart. And to me, this has been, for the most part, an exemplary inquiry. It's exactly how inquiry should go. So you've all collaborated. I know you're all fighting your own corners, but you've worked really, really well together, and you've worked really hard. It's run to time, and yes, the programme was really good as well for me, just to give me a bit of space and time to consider things. I've had to do very little people management, which is excellent because it allows me to concentrate on the evidence and not actually the management, which is what I'm here to do essentially. I know how much effort goes in behind the scenes, so I'm familiar with all your faces, but I know there are other people working really hard as well. So thank you to all of those, and I do wish all my inquiries were as good and as smooth as this. We seem to have started on a heat wave, and I think we're going to finish on one as well. So I'm glad I've done the site visits now. I wanted to thank a few people. So thank you for all those involved in getting me documents, arranging the site visits, Tower of London visit, etc. Thank you to the council for the venue and hosting us really well. Lots of good rooms and good tea and coffee at good times, which is always very welcome. Thank you for the models. I mean, I've no idea how you're going to get them back. But I will have a look at them before I leave again, as well as asked. But they have been a useful tool, and just to actually have in the room throughout the inquiry as well as an aid memoir has been helpful. Thank you to the programme officer, Joanna Vincent, from me for all the hard work. Keeping the show on the road, so to speak, and the website has been brilliant, and really it's not failed us once when we're all trying to furiously download the same core document that's been brought up, so thank you for that. Obviously these are serious events, but this has been good humoured, as has been reflected. I think some of my favourite things have been me starting less than professionally in my flip-flops because I didn't have any shoes. All the talk of neighbours. You know, I'm a child of the 80s, but yes, I did cry. I don't know if anyone else watched it. Apparently it was Channel 5's most watched show of the year. I checked last night. Some other points, so I think it was Mr. Philpott's reference to being in the Alford Groove, which I appreciated. The many names of Dr. Barker Mills, got that one right this time as well. The reference to Blobogram, which I will try my hardest to get into the report, but maybe struck out. I am sad I didn't get to go to Italy and New York on the site visit, but you know. And I do know people have rearranged holidays and such like to be here, and some have disappeared off on holiday now, having survived examination. But I think everyone deserves a well-earned break after this, so I hope everyone is having some time off. And I think that's it for me. If there is any feedback to pins, we always appreciate it, so please send that. I don't get to find out unless it's so bad it's a sackable offence, I guess. But they don't. But other than that, that just leaves me to say thank you very much. The inquiry is officially closed, and now my hard work starts with writing 4 schemes up into one mega Secretary of State report. But it'll keep me busy for a while. So thank you very much, everyone, and the inquiry is officially closed. Thank you.